Good afternoon, and welcome to the Appellate Division, First Department. Today we have over 7 hours of oral argument time requested. So, as I call the calendar, please only request the time, not that you want, but the time that you need to make your most salient arguments. And trust me, you already know this. We are prepared. This bench is prepared, like all of the benches. So we've read the briefs. We're familiar with the issues in your appeals. And certainly for those of us who are here for the first time, the white light on the lectern will go off when you have 2 minutes left, or if you've requested less than 2 minutes. Certainly it will go on immediately. And when the light turns red, that means it's over. Your time is up. Now, if the panel has more questions past the allotted time, past the red light, we will certainly keep asking them and you'll have an opportunity to respond. So, when I call your case, please rise, tell us who you represent and how much time you are requesting, how much time you need and not want. All right. Keening v. Bloomberg, LP. All right. Okay. So, appellant 636 and T.O. Children. Submitted. Let me say, if I mispronounce the name, forgive me and you'll correct me. Guaman v. 240 West 44th Street, 2. You said 5? Oh, okay. Uh-huh. Okay. All right. So 3, 1, 3, 3. Okay. Uh-huh. All right. Well, let's see what happens, all right? Thank you. All right. Ortiz v. City of New York.
You skipped it.
Oops. I skipped. Let's try again. Okay. Serta v. Sedonia, West 71st. Uh-huh. Okay. Okay, let's see what we got here. All right, I'm going to do 5, let's see, give me a second. All right. 5, 2, 4, 3. I think I covered everybody. Did I cover everybody?
One more.
Oh, one more. Okay, 3. Thank you. Now, Ortiz v. City of New York. Uh-huh. All right.
Good afternoon, Your Honor. Plaintiff respondent requesting 5.
Okay. 5. I'm gonna throw in a bonus for you. 525. All right. Rounds v. Ahmed. All right. Okay. 525. Mm-hmm. People v. Ruffin. Okay. 616. People v. Duchesne, that's submitted. Cochancella v. Sutton Place South. Uh-huh. All right. 626. Bank of New York Mellon versus Kim. Let me find out. Does anyone have any questions? No questions? Okay, submitted. Thank you. All right. People v. William Rivera. Uh-huh. All right. 727. Piscatelli v. Deloitte Services. Uh-huh. All right. 424, thank you. Rosenblatt v. Rosenblatt. Uh-huh. Four, two, three. All right. People v. John Rondas Terraris. Submitted. Rubenstein, Public Relations v. Fleet Financial. Mm-hmm. All right. Four, two, three. Mm-hmm. People v. Thompson, that's submitted.
No, they're here.
Did I miss one?
No,
It's not submitted.
Forgive me. All right, so let's start again. People v. Thompson. Okay. All right. 424. All right, thank you. All right, Edward Tyler Naim, Fine Art.
I hear for plaintiff, respondent, we're willing to submit, Your Honor, unless the court has any questions, and adversary is not.
Yeah, well, let me find out from my colleagues. Any questions? No questions. All right, submitted. Thank you. All right. Give me 1 second. Thank you. All right, first case up, Keenan v. Bloomberg. All right, you ready?
I am, thank you.
Okay.
May it please the court, my name's Elise Bloom. I am representing the appellant, Bloomberg LP, and I'm here today on behalf of my client asking you to reverse the decision of the trial court which denied our motion to dismiss all of the claims in the case except for the plaintiff's retaliation claim during the time period of 2022 through 2024. This is an employment discrimination case. The claims are for sex and age discrimination. The plaintiff was a newscaster here in New York, and the case really involves three very discrete periods of time. The first period of time is from 1999 until
So the claims, aren't they really continuing claims of the same type of behavior?
No, Your Honor. While they are claims of discrimination, the first set of claims which started or are alleged to have started back in 2012 and were alleged to have continued until 2015 were based when the plaintiff had a specific job. She was a broadcaster for U.S. News, and she had two particular sets of supervisors who left Bloomberg in 2016. She has no allegations of any type of discrimination or retaliation during the second discrete period of time, which is 2015 until 2019. Her allegations pick up again in 2019, at which point her job has changed. She's still a news reporter, but her responsibilities are to cover news in Asia.
Well, isn't that because she was assigned those things? I mean, she really didn't ask for those because they messed up her time schedule and made her work very late. But I mean, she was still working for Bloomberg News as a reporter, and she alleged that there was, she at least alleged, this is a 3211 motion with a 60-page, fairly detailed, verified complaint. And she at least alleges at this point that there was a continuous situation going on there. And how can we break that up and say absolutely not at this stage?
I think you can break it up based on the allegations in her complaint. And I agree, it is a sprawling 300-paragraph plus complaint, but it's mostly filled with facts that do not have legal significance. They're legal conclusions. But to answer your question, if you look closely at the facts as alleged in the complaint, I think the most salient thing that you will see is that she alleges nothing, no acts of discrimination or retaliation during the period of 2015 through 2019.
Counsel, it just seems to me that over a period of time, you know, as she makes the complaints, things worsen for her, you know, as it relates to, just give me a second.
Sure.
You know, being passed over for younger employees, having the office ships, it just seems that as she complained, the circumstances got worse. Can you address that?
Absolutely. Absolutely. There's a long period of time. First of all, as I said, her job changed from being covering U.S. to then covering Asia. And then there's a long period of time where she doesn't complain at all. In fact, no allegations of discrimination from 2015 to 2019. And if you look at the complaint, her next complaint, actual complaint about her conditions, is in 2022. And even assuming that the court were to say that she could satisfy the continuing violation doctrine as to her disparate treatment claims, the complaint still does not state claims for disparate impact, because as your honors are aware, in order to have a claim for disparate impact, you have to have a facially neutral policy which is shown or alleged to have had an adverse impact on people in a protected category, which in this case would be older people and or women. And you have to come forward at least with some allegations of some statistics to back that up. And if you look at the allegations in the complaint, with regard to her disparate impact age discrimination claim, there's no allegations of, there's no statistics at all that are proffered with regard to age discrimination. The only statistics that are provided are statistics that are alleged to be connected to the sex discrimination claim. And as to those statistics—
What about her claims regarding being paid considerably less than male employees?
Well, Your Honor, as to her disparate impact claim, The disparate impact claim is alleged that, she alleges that that's the result of actions that are taken by a committee, the Editorial Management Committee, which the complaint says came into being in 2015. And in order to sustain her disparate impact claim, she would need to show that it was somehow the actions of that committee resulted in women and older people being paid less money, and you'd have to show some statistics to support that. So number one, her complaint does have some allegations that predate the existence of this committee, but I think more specifically, remember, she worked in New York, and the only statistics that she proffers that would go to her disparate impact claims are those as to the UK, and then she has some allegations about 8 years old in the District of Columbia, but nothing as to New York. With regard to her equal pay claim, a few things that I think are significant are from a legal perspective. Number one, you have to proffer statistics or some statistical allegations in the same establishment. Again, the only statistical allegations that she comes forward with have to do with the UK and Washington, D.C. In addition, the Equal Pay Act, the New York Equal Pay Act, did not cover age discrimination before 2019, and it's not retroactively applied. So any allegations, any claims under the Equal Pay Act prior to 2019 would be time barred. I see that my time is up.
Thank you.
Good afternoon, Your Honours. May it please the Court, Neil McGillivray on behalf of plaintiff respondent.
Counsel, how do you respond to your adversary's allegation that between 2015 and 2019 that there were no allegations of discrimination?
Well, what she has alleged here, and I think it's the argument was focused on the retaliation claim. So what she says is that she made repeated complaints beginning in 2012 and 2013, and that as a result, and again, not all of them may be detailed in the complaint, many of them are, but she says for the next 10 years, every single year, and it was a yearly event that her pay was up for review, every single year her pay was frozen at the beginning, and that continued for the next 10 years. So whether or not, and again,
So it's the freezing of the pay yearly, that's the discriminatory act?
is the act of retaliation, the alleged act of retaliation. Now again, all of this, I mean, in terms of my opponent here, she had made the point on a number of occasions that she has to show. Well, that's a matter for whatever the evidence shows. That would be a matter of summary judgment. For now, she just has to allege. So what has she alleged? And again, the complaint is very, very detailed in this regard. But simply because it's so detailed doesn't mean that it contains every single detail. And obviously, there are many details that are outside her direct knowledge in terms of the motivation on the employer's side for why certain decisions were being made.
Well, counsel, what your adversary alleges is that while it's a sprawling complaint, the allegations don't have any factual weight regarding the legal claims. How do you rebut that?
And I think, look,
With
she's
specific allegations in the complaint.
indeed. So the focus is on what is described as the gap between 2016 and 2019. And certainly within the complaint, there are no specific complaints detailed there, but there are many complaints before then, and the allegation in terms of the retaliation is that the retaliation, I mean, you don't have to keep making complaints for the retaliation to continue. So the argument here is that the complaints were made beginning in 2012, and that retaliation continued all the way through in terms of her pay, in terms of her bonuses, but also in terms of her other working conditions through the end of her employment, and that more than suffices. My opponent had pointed to the disparate impact claim. The very same claim was found in the Duggar case that we cite within the brief to meet the heightened pleading standard in federal court. The allegations are exactly the same. It's pointed out that we don't have a full range of statistical evidence. We don't need the full range of it at this point. We simply need to allege. For purposes of the equal pay claim, we just have to point to comparators, what we have done, which is what we have done.
Where in the complaint did you make those specific allegations?
In terms of comparators, Your Honour?
Yeah.
Yes, so I believe it's pages 24 and 25 of the complaint. I think it's paragraphs 42, 52, and 53. So there are two male comparators, and one female.
Because now with the female, and I'm glad she went there, I believe there was a younger, less experienced employee that received a higher bonus.
Correct.
Also, more junior employees also received a higher bonus, and is related to certain male employees, a $25,000 to $50,000 bonus more than the plaintiff.
Exactly, Your Honor. I think in terms of the three people, she points to one male comparator who worked alongside her for the time she was there. She points to another male comparator who was substantially younger than her, earning far more and getting a far greater bonus. And as Your Honor points out, she also pointed to a younger female comparator. So, and again, the statistical evidence is, in terms of the disparate impact claim, you have this editorial management committee that is making decisions across the board in terms of Bloomberg. So it's not simply the New York office. And that was the point that was made in the Nduga case. These decisions are across the board. So the statistical evidence with regard to Washington, D.C. in particular is directly relevant to New York.
Are the boards changing from year to year?
Excuse me, Your Honor?
The members of the boards, are those individuals changing from year to year?
That I don't know. What is alleged is that, I'm not sure that they do. I think there might have been one change, but certainly it remained an all-male committee. I think there was a point at which, no, let me restate that. As memory serves from the complaint, there was a female member appointed for a very short period of time. So it went from all-male to a female member and then back to all-male again. But in terms of the relevant period here for purposes of the disparate impact allegation or claim, the committee is all-male. I think in terms of the continuing violations doctrine, I think it's clearly made out. And again, it's a fact-intensive inquiry that can't be determined at this point. She has alleged the discrimination from 2014 onwards, and she's also alleged that from the very moment she began working there, she was earning less than her male equivalents. And again, she points to that one particular male comparator who worked alongside her for the entire time. In terms of, I know there's a lot...
When she started working there, the allegation is that she was promised an increase, right?
Well, the allegation is twofold, that she was started on a lower rate and told that it would improve as her employment continued. In fact, the opposite happened. It deteriorated significantly in that regard. Otherwise, Your Honours, if there's, I don't know, I think there's an argument too made in terms of the retaliation, that a 2-month gap between the initial complaint and the initial act of retaliation is insufficient. That's not what this court has found. I think the Hersovitz case in particular says there's no bright line rule, and what we've alleged here, a 4-month gap, is easily within the temporal proximity requirement if you're looking to establish causation for purposes of pleading.
Thank you.
Thank you, Your Honours.
Thank you. Just a few quick points. I'll start with the Nduga case. One significant difference between the Nduga case and this case is that Ms. Nduga worked in Washington, D.C., and the statistics that were proffered had to do with the Washington, D.C. office. The plaintiff in this case worked in New York. She
But we're
never
really
worked-
talking about the types of allegations that need to be made as opposed to specifically what office it was. And as we know, the federal court has a little bit of a higher pleading standard, but it was still okay.
Well, as to the type of allegations, I want to talk about the type of allegations in a moment, but for a disparate impact claim, you have to proffer some type of statistics that are relevant and that deal with the establishment where the plaintiff worked. The key difference between Nduga and Keenan is that Nduga worked in D.C. and offered D.C. statistics. Keenan worked in New York and offers no New York statistics. And I'm glad that you raised the point, though, about pleading standards and similarly situated. And I was happy that my adversary also referred to the Hershkowitz case, because I think a close reading of the complaint in this case demonstrates that while there's a lot of allegations about a younger, more inexperienced person or a colleague, other than paragraph 143, where you can see the plaintiff knows how to make a specific allegation if she has one, In paragraph 143, she specifically refers to a younger female by name. The other allegations in the complaint are all legal conclusions and things that this court has held both in Ershkowitz, in the ATN case, and in the Anda Haraji case to be legally insufficient to state a claim of discrimination. You have to give more specifics than just a younger, less experienced colleague. You need to allege more about the person's experience. You need to allege at least that they had the same job, that they worked in the same workplace, and a close reading of this complaint, while very, very long, I think shows that the allegations are very general and do not meet the specific pleading requirements that this court has
I'm just
endorsed.
looking through the complaint again quickly. I mean, there are several names of people who were involved. There were several allegations that people started sooner, started afterwards, that people had less experience, that they got better time frames, they got better positions. I mean, those are alleged. Again, on a complaint, I really think our court gives them a little bit of a leeway. I think you're asking for a little bit more information on the complaint than she really needs to give at this stage.
I think in terms of the names that are mentioned in the complaint, it's more about who her supervisors were, which punctuates the point about the different time periods. She talks a lot. If you look at 52 and 53, a male comparator 20 years her junior with lesser credentials and nearly an identical job. Paragraph 53, a second male comparator with similar experience and skills performing substantially similar work. She doesn't provide real specifics about how much more or how much less experience. And while I understand that it's a lenient pleading standard, it's not a non-existent pleading standard. And while the court may ultimately find that's enough for a disparate treatment claim, she still has not met the pleading requirements for a disparate impact claim or for her equal pay claims.
Thank you, counsel.
Thank you very
both.
much.
Guaman? Let me say that I'm going to correct myself, okay? So with respect to the appellants, I'm going to do 5-2 and then all the respondents 3, okay?
Yes.
All right. Please begin.
Yes, may it please the court, Rosanna Vargas on behalf of the appellants.
You could move that closer yeah, that's better.
Thank you. There, Rosanna Vargas on behalf of the appellants. And here we respectfully request just 3 items, and now we'll be requesting the reinstatement of the appellant's contractual indemnification terms against Ground Force, the leave to assert the indemnification claims against Lowe Allen, and the dismissal of plaintiff's labor law claims in its entirety. The Ground Force contractual indemnification obligation should be enforced as the party's intent and the party's obligation should be fully enforced by the court, as the lower court mislabeled the contractual cross claims as moot, since Ground Force initially had made a summary judgment against plaintiff and that was granted. The court did not address our cross claims of indemnification. The contract should be enforced and the intent of the parties should be seen and also allowed to be obligated as both parties intended to be legally bound by.
So even though the court dismissed plaintiff's complaint against Ground Force, right, you still have cross claims against them, which maybe have to be converted to third-party claims now because they're no longer, but that's what you're asking for, right?
Yeah,
In the first instance?
That's perfect, yes, Your Honor. As the contract says any actions or any performances that arises from ground force, and it also tiers up to everyone, which it includes my appellant that had the contract with ground force. And even though it was dismissed against ground force, we still are in the middle of the litigation itself against plaintiff. And in the alternative, the court can conditionally grant indemnification in the event that the appellants are found in any way liable or in liability against the plaintiff. Ground force should be obligated to perform under the contract, which is to provide indemnification to the appellants. We also continue that we request the leave to amend and assert indemnification claims against Lowe Allen based upon the same contract that we're discussing now of the contract between Ground Force and Lowe Allen, which is in the record 1408. It's the same indemnification language that we're requesting that Lowe Allen be forced to provide to Ground Force and then eventually up to Ideal. We had requested under 3025B of leave to assert this indemnification claim against them, which is usually freely granted. It's not prejudicial to any other parties because all the depositions, the evidence, and everything regarding the contract was already admitted. It was already.
Was your motion seeking this amendment made after the discovery ended?
Yes.
And so why was it made so late along in the game here?
We do not need new discovery. We are not requesting new depositions. We're not requesting to contest at any way the contract. We want to assert this indemnification against Lowe Allen, and there is no new claim. It's essentially the same claim, it's the same contractual chain, and it's already been litigated from the beginning, from the bottom up, so it should not be
To that
prejudicial.
extent, the contract had been exchanged years prior. What's the reason for seeking such a late amendment?
Especially because ground force was, well, the complaint against ground force has been in favor of the plaintiff. And we now want to also seek indemnification against Lowe Allen, since we did not seek indemnification enforcement against Lowe
The
Allen.
question is, if the contract has been in effect for such a long period of time, what was the delay in amending the complaint or asserting this claim?
Yes, so the delay is, there's essentially two contracts. The one that the appellants have with ground force, and then the separate contract of ground force against Lowe Allen.
Now,
So
you know, the
delay-
principal of Lowe Allen denies even signing the agreement. So how should we consider that?
That's perfect, Your Honor. So they deny signing the agreement. However, they performed under the agreement for various years. They intended to receive
But
payment.
in order for the contract to be effective and received by the court, it has to be authenticated. What evidence in the record do we have that it was authenticated?
Yes, so just to be clear, the contract between Lowe Allen and Ground Force, correct?
Yeah.
Yes, so it was authenticated regarding the totality of the evidence and the totality of the circumstances because they continued to perform under that contract for years. The Ground Force was paying Lowe Allen for their performances. Lowe Allen continued to perform exactly as the contract was stated, and they didn't sign the contract. They signed the invoice itself, and then the contract specifically states out all the other terms. So based on the performances and based on the services rendered, receipts of
I
payment.
just want to go back, because you said there's evidence, but I don't recall seeing any emails, any correspondence between these two parties regarding the agreement. You said there is evidence?
I'm relying on the invoice, which is record 140807, which shows that it's signed by both of them. The invoice is right above the contract. It's signed with the totality of how much they wanted, well, how much they were going to get paid for the entire project, the materials and the labors that had to be provided. The contract that follows that was not signed by Lowe Allen. However, they receive payment, they continue to perform under it, and they continue to provide workers, and they supplied the masons to the project itself at ground force request. And the performance and the payment itself should prove that even without the signature, both parties intended to be liable and held accountable.
Thank you.
Thank you, Your Honor.
Good afternoon. Appellants wrongfully stated that the.
Just state who you represent again, please. There's so many of you.
I jumped right into it. Emily Ashman for Respondent Ground Force.
Okay.
Good afternoon. The appellants wrongfully stated that the lower court did not discuss in its decision dismissing the claims against Ground Force the reasoning why. It was fully set forth in its reasoning why it was the same reason that the complaint was dismissed as from the plaintiff. So the cross claims were dismissed for the same reason that the plaintiff's claim was dismissed. Also, the lower court thoroughly reviewed this in the motion to re-argue and again denied the motion to re-argue. So it's not as if the lower court didn't go through the issue of the cross claims. This was gone through. Appellants also discussed the arising out of trigger in the clause. The lower court properly dismissed the appellant's cross claims for conditional indemnity against Ground Force based on there was an unauthenticated and inadmissible insurance agreement, not a subcontract. In order to trigger the arise out of obligation, there must be a showing of a particular act or omission in the performance of the work causally related to the subject accident. The lower court correctly found no causal relationship between Ground Force and plaintiff's accident to hold Ground Force liable to the plaintiff. York and 240 have liability based on the fact that they were the owner and the general contractor, and they were not indemnities under Ground Force's contract with Ideal. York owned the saw. Appellants are responsible for plaintiff under the labor law. Ground Force had no active involvement. There was no active negligence. They had no presence whatsoever on the project, and there's nothing whatsoever in any contract imputing this.
Anything else, counsel?
I just would add that plaintiff's underlying motion, cross motion, was untimely, made quite some time after the filing of the note of issue, with no leave sought and no reason set forth in contravention of the well-accepted standards under Brill.
Was it
Questions?
Was it nearly identical for us to decide it?
What?
Was the motion nearly identical?
No, it didn't rely on the same underlying facts at all.
Thank you. Just state who you represent. Thank you.
Hi, good afternoon, Your Honors. Josie Connolly from London Fisher for the respondent, and third-party defendant Lou Allen. Just to express in the motion, there is a considerable issue of fact, which is why the appellants are still in this case.
The issue of fact.
They provided the circular saw to the plaintiff. The circular saw was wrapped in a wire tape. It was aged. It was allegedly defective. And there was a lack of a secure element on the saw as well. Plus, plaintiff asked York, who provided him with the saw, that he needed a table for stability reasons. York didn't have any table to provide, and they said, go in the closet and get what you can, and he got a bucket, which wasn't the wisest thing to use, and he used a circular saw. Lou Allen was not supervising plaintiff that day. There was no need for, there was no circular saw provided by Lou Allen, and York never reached out to Lou Allen to say, hey, your employee is looking for a circular saw. Is it okay if we provide it to him? Now the appellants are seeking to implicate liability upon Ground Force and Lou Allen based on this contractual indemnification clause, but they have a non-delegable duty owed to the plaintiff. And the courts have held where the indemnities and appellates like themselves have failed to provide evidence that they're free from negligence, they cannot rely on such a clause.
They could be entitled to conditional indemnification, right?
Well, Your Honor, the courts also said that it is premature to issue conditional order as to indemnification where facts exist as to whether the indemnity of the appellants are potentially negligent in this matter. And that's the case here. It was them who provided the saw. It was nobody else. Nobody else was supervising. Nobody else controlled or directed the work. It was York themselves.
So one of the things they're asking for is to amend the court's order to the extent of allowing them to amend their cross-claims to have a cross-claim against you, which they don't have at this time.
Right, Your Honor.
And why should they not be allowed to do that? It seems like, to the extent I can see in the record, the pages she cited, 1407, 1408, there is a contract that is signed by the party. So why shouldn't they bring you in? Because you've known about this all along.
Well, our position is that there is no contract. The principal of Lou Allen testified that he never executed any contract. There's
He's saying it was forged? Is that what he's saying?
Yes, he's saying
I do
it's
see a
not-
signature.
It is saying, but even if, there's two contracts that were provided. There's one dated May 5th of 2017, and there's one dated June 1st of 2017. The appellants kind of blend the contracts together. The May 5th, 2017, that was not signed with absolutely no signature, but a signature from Ground Force, provides the generic contractual indemnification language. Nobody from Lou Allen executed that contract. The June 1st, 2000 contract makes absolutely no discussion of contractual indemnification obligations. It's a mere invoice for services of manpower to be provided for bricklaying, the hourly rate, and the amount that Ground Force had to pay. Lou Allen's superior, he testified that he never entered into a contract. It was his custom and practice with Ground Force to get a telephone call requesting, I need such and such number of men on the job site. They would go back and forth. They would provide the workforce and give the hourly wage and the invoice amount. Even Ground Force's principal admitted that they were unaware of the existence of any contract, that it was custom and practice with Lou Allen to provide bricklayers and provide the invoiced amount. And
Thank you, counsel. Thank you.
all right, thank you.
Good afternoon, Your Honors. Travis Wong from William Schweitzer and Associates for the plaintiff respondent. Although counsel didn't get to address the labor law claims yet, I think it's important that the Supreme Court properly granted plaintiff's motion on two separate industrial codes. The first being Industrial Code 1.23-1.2 sub C sub 1. And that requires that all power-driven saws be equipped with a guard as specified by that code. Here, the evidence is very clear that the guard on the saw that plaintiff was using was not working.
And was there any dispute as to that in all the evidence here?
There's absolutely no dispute as to that. Therefore, plaintiffs made a prima facie showing that defendants violated this, and while he was using it, the saw jumped back and struck him. Thus, their violation was a proximate cause of plaintiff's accident. Additionally, the court also granted plaintiff's summary judgment motion on 23.9.2a, which requires that a saw that is in a defective condition that places an affirmative duty on employers to correct by necessary repairs any structural defects or unsafe conditions in equipment or machinery. This saw was described as old, heavy, was defective in the fact that it would stop and go as plaintiff was using it, and had electrical tape surrounding its cord. Accordingly, plaintiff respectfully, it's our position that the Supreme Court correctly granted that part of the motion. With respect to plaintiff's claims under Section 1.5C3, which requires that all safety devices be in good condition and repair, it's plaintiff's position that the court correctly denied defendant's summary judgment motion on this. At the very least, there's a question of fact as to whether or not defendants had actual notice.
That's not too general of a industrial code violation to have 241.6.
Absolutely not. There's a plethora of case law that it is specifically sufficient, and the case on which defendants rely, Zino, doesn't actually say that it's not sufficiently specific. It actually states that 9.5, which was the industrial code, and that was more specific. And therefore, that was the code that applied. But it doesn't in any way say that that code is not sufficiently specific enough to support a Labor Law 241 sub 6 claim. If the court has no further questions, I will rest on my brief.
Thank you.
Thank you.
Give me 1 second.
Yes.
I believe there was a question about additional time. Actually, you did. Okay, all right.
May I begin?
No, I have to set the timer, okay?
My apologies.
No need to apologize. You did nothing wrong. But what I'd like you to do is to address plaintiff's arguments with the labor law 240.
Yes, yes, Your Honor. So plaintiff, my esteemed colleague, incorrectly said that there was a design defect. At this point, the saw, there was no design defect, there was no
It
structure.
was missing the cover that's supposed to be on it to protect it from falling and chopping off someone's hand.
Yes, well, plaintiff said it was missing a cover, but on the same way, he also testified too, on record 177, he admitted that the balancing wood in an upside-down bucket and cutting himself because it only got stuck. And they provide no
Are
expert,
you saying that that's a question of fact?
but I'm,
That creates a question of fact? A saw in the condition that it was, that had electrical tape holding it together? The fact that it was being used on a bucket, which plaintiff was directed to use, creates a question of fact?
no, Your Honor. What I'm saying is that it's the plaintiff's sole proximate cause that he caused his own injury.
How is that? Because, you know, certainly the saw was provided, he asked for a table, it was directed, there is none, you can use this bucket. He was directed, so how is he the sole proximate cause in light of the condition of the saw, as my colleague just indicated?
Yes, in light of the condition of the saw, there's also that the eyewitnesses that were there also testified that if they would have witnessed this ahead of time, they would have told them that it was an unsafe and unauthorized way of using the saw. And he's alleging that he was told to use that table. However, it's based on
Well,
plaintiff's employer.
it wasn't a table, it was a bucket.
I'm sorry, the bucket, yes.
Problem was
He's
there
a-
was no table. That was part of the problem, so that's why
Yes.
I used the bucket.
Correct, and yes, he alleges that he was told to use the table, and as being an employee of Allen Lowe, it would have been for him to follow what he's told in the site inspection meetings and the toolbox meetings, which is to properly follow safe.
But the issue is not about properly following safety, is whether in fact the instrument that he was given to use, the saw, had the necessary safety mechanism on it, which it did not.
Yes, plaintiff alleges that it did not. However, it's also plaintiff's own volition not to continue and contact his own employer.
That's what our cases say?
No, but it's also
So
plaintiff
counsel,
used his
that's
own poor
comparative
judgment.
negligence. You're talking about comparative negligence. If there's 1% negligence on the part of any other individual, then that would not be the sole proximate cause. And our case law, as our colleague says the opposite. As long as there's something that's negligent on the part of your client, being that the saw was missing the safety mechanism, then it's incongruent. It cannot be. If there's a violation of the industrial code, there can't be sole proximate cause.
Yes, yes, and then in the same fact, plaintiff also testified that it got stuck. So if plaintiff testified that it was missing, how can he also testify that it got stuck? The same saw that he said wasn't on the actual saw itself. He said the metal wasn't there.
That just adds to the equation. It means there's more than one thing that's wrong, and therefore it can't be a sole proximate cause.
It adds to the equation that the plaintiff incorrectly used the saw itself because it would have gotten stuck if he used it in the improper manner.
Counsel, thank you.
Thank you.
Thank you all. All right.
May it please,
Serta.
may it please the court, Nicholas Calabria of Amity Demirs McManus for the appellants Sedona W71 and CCNY Construction, Inc. We're appealing a denial of a motion for contractual indemnity against our subcontractor, Standard Waterproofing, and also the finding that Labor Law Section 240 was violated. On the contractual issue, I believe it's clear that either Standard or their subcontractor, Zuntos, was negligent in this matter for failing, if the 240 is granted, failing to secure a scaffold plank. One of them was negligent. In either case, the indemnity agreement would be triggered, and Standard would owe contractual indemnity to the owners, who have both been found not to violate Labor Law 200, so their negligence is not in play. And I would point out that Standard has not opposed that on this appeal, their briefs. They submitted a respondent's
So are you seeking
contractual,
conditional?
at the very least, conditional. But I believe since either or is negligent, either Standard is negligent or Zuntos, they're the two companies that were maintaining and moving the planks on this scaffold, so one of them was negligent.
You weren't.
I wasn't.
You're-
It was one of, if it was one of them, and if either of them were negligent, I'm entitled to contractual indemnity.
But isn't there a carve-out in the event that they also were negligent and that hasn't been determined yet, so it would be a conditional
That's
situation?
why it would be conditional, but I would
Right.
think with the granting of the 240, it had to be one of them that they were the only people that were maintaining this scaffold. So one of them had to be negligent, and if either of them are negligent, we're entitled to contractual indemnity. And again, they have not
How about Arsenal? How does Arsenal play in the picture? Is the possibility that neither could be
Well,
negligent?
Arsenal testified, and it has not been rebutted, that they put together the scaffold, that they put in the planking, and that it was common that the planking would be moved on the bicycle scaffolding, and that once they put this scaffold up 2 years before the accident, they would come in once every 6 months to do a New York State inspection.
Isn't it true we're not sure exactly what happens? Isn't the better course to wait and see if there's any liability as to Arsenal, Standard, or the other subcontractor?
And in that case, we should get conditional contractual indemnity. Moving on to the 240 case, I believe that questions of fact have been raised regarding the...
What questions of fact when we have something falling from above and striking the plaintiff? What are the questions of fact here?
Well, first of all, it has to do with credibility of the plaintiff. When he initially went to the hospital, he had a complaint that something fell.
Are those records even admissible on this motion?
Oh, definitely. These were party admissions made by the plaintiff, and they're directly, if you look at the quotes, it's an interview of the plaintiff telling him his history regarding the accident.
And how is that germane to care and treatment so that they would be,
Well, it's a party admission. It's against, he made it against, it's against his interest in the story that he's telling at his deposition a couple of years later.
But it's still in it's still in a record that we have a question about whether or not that's admissible.
I don't know how they are admissible. I was under the impression that the medical records are not certified.
Yeah, that would go to the business exception to the hearsay, but I'm proposing that it's an admission by the plaintiff, and that's always admissible.
So, counsel, you didn't answer the question. It also has to be germane to treatment. So how does whether it was tied down or not tied down, any of those facts germane to a treater?
Right, and that goes to that.
Isn't that the
goes to that-
evidentiary standard?
Yeah, but not on the party admission. On the party admission, if he gives makes a statement that's against his interest, that's admissible regardless of where it's made, if it's in a hospital record or anywhere else.
No, you're talking about credibility. I know that you also raised the fact that the plaintiff used a different name with the contractor, but what, if anything, does that have to do with the fact that he had an accident? I mean, no one's disputing he had an accident.
Agreed.
And it was an unwitnessed accident, correct?
Yes, he's the sole witness under a Labor Law 240
That-
case.
But we have lots of those cases,
I know we do.
right?
And then, but the question of credibility comes up again because the owner, Zunto, said this gentleman was a helper. His job was to mix cement and clean up the area.
Doesn't matter what he's doing when the thing falls from above on top of him.
But he shouldn't have been there. That doesn't mean that if it had fallen on him. But the thing is, he says that his boss told him to go on the scaffold and do that work. We have an affidavit from that boss saying, I never told him that. I never saw this gentleman ever work on a scaffold. He was a helper. He wasn't, this is a story. This goes to a story. It's credibility. Did this accident happen in the manner that he said? Well, the only person that says it happened that way is the plaintiff. Everything else says it could have happened some other way.
What everything else?
The medical records, the testimony that he was not a worker that was in that area.
Who testified to that?
There's an affidavit from a Mr. Gonzalez at page 2317, who is the plaintiff said that's the gentleman that told him to go and do the work on the scaffold, and his affidavit says, I never told him that.
That doesn't mean he wasn't there.
But see, I'd agree to you. I'm
Is
not.
there any evidence
I
that
said it goes to credibility.
Is there any evidence that that the plaintiff was specifically told not to go on the scaffold?
No, he was never assigned. He says he was assigned to go on the scaffold that day. Mr. Gonzalez says, no, I never told him that. So right there's an issue of credibility. And I
Thank you.
believe
You can
in
follow up on
total-
rebuttal. Thank you.
It's just in totality, Your Honor. Thank you.
Thank you. Give me one moment. Thank you. You can come up and just give your appearance. Thank you.
May it please the court, my name is Catherine Weiss from Milburn, Macris, Plusatis, and Sidon. I'm representing the appellant respondent Standard Waterproofing in this matter. I'm arguing that the lower court improperly denied Standard's motion for contractual indemnification against plaintiff's employer, Exontos, and also opposing CCNY and Sidonia's appeal of the lower court's decision denying contractual indemnity against my client, Standard. First and foremost, Zontos is obligated to indemnify Standard as a matter of law based on the terms of the contract and the testimony of the key witnesses. Case law is legion that when there are clear and explicit terms in the contract, such as here, that indemnity is warranted. Here, the language is that Zontos is obligated to indemnify Standard for bodily injury or claims of bodily injury arising out of Exontos' work under its contract, excluding only liability created by Standard's sole and exclusive negligence. In this case, with respect to authentication of the contract, we had Exontos' president, Marcos Villaverde, that was a signatory, indicating that.
So with respect to the indemnification,
Yes.
Aren't there questions of fact as to Standard's negligence?
There's actually, I would respectfully argue that there's no questions of fact. Exontos directed, supervised, and controlled the work. The lower court held, and no party has disputed the fact that at the time, Exontos was required to perform all work that Standards was required to.
Wasn't there
including-
some information or testimony that Standard bought additional scaffolding to maintain the site?
I would say that that's not determinative of negligence, because in this case, Exontos was required to maintain a pre-scaffold
Not determinative, but raises questions of fact.
I think that the fact that whether they brought those planks or not is irrelevant, because before getting on the scaffold, Exontos had the contractual obligation to have a meeting to discuss the scaffold, and then they had to inspect it. And ultimately, their worker, the plaintiff, got on that scaffold.
So, counsel, isn't it true that Standard brought some type of wire to secure the actual the actual planks to the bicycles? Wasn't it your job to do that, and that wasn't the vehicle where it fell?
Well, in fact, Standard passed down its contractual obligations to Exontos, and even if they did bring it,
Didn't you have a contractual obligation and you actually brought the wire? I thought that was the testimony.
Your Honor, in Williams v. City of New York from the First Department in 2010 held that a party seeking indemnity does
Has to
not,
show it's free from negligence.
but also that they actually exercise any authority over the plaintiff's work on the morning they were injured. This did not happen here.
That's actually a different standard. That's a means of methods. You're mixing up means of
Sorry,
methods.
Yeah,
respectfully, Your
and I
Honor,
just want to go back to the
understand.
testimony, because it's actually page 1732, and I believe it was Mr. Mikanu, who indicated that it was Standard that was responsible for securing those additional wooden planks. That's on 1732. So how do we factor that in?
Well, that's actually contrary to what the contract says, and in
But
any
it
event,
raises a
they
question
weren't.
of fact as to Standard's negligence, does it not?
Well, they were not the ones responsible for ensuring the safety of Exontos' employees. That would be the job of Exontos, and their foreman, Alejandro, was on site, and there's no dispute as to
I don't
that.
think that's completely clear, because as we were saying, you provided the wire, you provided other material there, and you also had a project manager and vice president that was going there pretty much every day and overseeing this. So you're not that totally removed from everything going on, and that's part of the concern.
I think that the Mr. Richard Deli from Standard, he was not there on a daily basis, but Mr. Gonzalez, on behalf of Exontos, he was. He was the foreman, and he was the only one that had any contract with the plaintiff. The plaintiff even testified that he was not aware of Standard. He only received directions from Mr. Gonzalez. He was the one who instructed him on where to work, how to work. And since the nature of his interactions were limited to the foreman that was Exontos' employee, whether Standard was there and had any general supervisory authority in this case would be irrelevant to the contractual indemnity claim.
Thank you.
If I may, as far as my opposition to the other motion, may I address it now?
Go ahead.
Thank you, Your Honor. To the extent that the CCNY and Sidonia are claiming that that they are entitled to contractual indemnity from Standard, well, whether it's Standard or it's subcontractor Exontos, I would say that Arsenal bears responsibility for the safe installation and the maintenance of the scaffold. So they're also, and Arsenal was not engaged by Standard. So at the very least, Standard is not responsible, and also I would say at a minimum, then alternatively that we would be entitled to partial indemnity, and if we're entitled to partial in the event that the CCNY and Sidonia are entitled to partial indemnity, then so would Standard.
All right. Thank you. Thank you.
Good afternoon, Your Honors. Andrew Kolowitz for Zuntos. I'm here on the limited issue of opposing Standard's motion seeking contractual indemnity. I think, frankly, the panel got it right. I mean, there was testimony from multiple parties that Standard brought the planks to the job site, that they brought the baling wire needed to secure the planks, and apparently or allegedly, these planks were not properly secured. William McIndoe's testimony, page 1732, as Your Honor properly pointed out, he was asked directly whether or not Standard would have brought these planks. His answer, yes. If those planks that were brought by Standard would have been secured to the bicycle by baling wire, would Standard have brought that baling wire? They would have brought it themselves. That was the answer. And he was asked, how do you know that Standard brought the wooden planks that would have been annexed to the bicycle? Answer, because I recall a conversation with Frank Ricciardelli where he stated he didn't have enough planks. He was going to bring more for access to the facade. That's just part of the testimony. My client also testified that Standard was on site weekly. They gave direction to my client's employees, including the plaintiff, and oversaw the work. So I think it's fairly evident that the lower court appropriately denied the claim for contractual indemnification here. And it was never preserved, it was never sought a claim for conditional contractual indemnification either. So, and frankly, on this record, where we could go to court and Standard could be held 100% liable here, I don't think an award of conditional indemnification is appropriate. And the lower court, at least with respect to my client, got it totally right. Unless there are any other questions from the panel, I'll rest on my brief.
All right, thank you.
Thank you.
Yes.
Good afternoon, Your Honors. Lori Parkman for the plaintiff respondent. So back to the main action, the court got it completely right when the court granted the plaintiff's summary judgment on the 240 sub 1 claim. As you noted, a part of the scaffold above him collapsed. That's a classic.
So addressing some of the issues that were raised by the appellant, saying that your worker was just a helper, a worker, he wasn't supposed to be where he was. He may not have been there. He told a different story at the hospital. He used a different name. What about some of those things? How can you address those?
Right. Thank you, Your Honor. The main thing with all of those is that they're exaggerating and misstating the record. There is no testimony whatsoever that the plaintiff was ever told not to go on the scaffold. First of all, they're relying on general testimony of the owner who is not on site, who says, "Oh, he was a helper," and generally helpers are not allowed on the scaffold.
Counsel, I'm glad you brought that up because there was also testimony that helpers at times were requested to work on the scaffold, and the plaintiff had the particular license requirements to do so. He was qualified to work on the scaffold.
Yes, thank you. Yeah, that witness, and it's at 1918 that you're citing, that sometimes the helpers did. But he, at 1932, specifically testified that he had never told the plaintiff to not go on the scaffold, and he didn't know of anyone who had. And they rely on the affidavit of Gonzalez, and that's not in his affidavit either. He simply says, "I did not tell him to go on the scaffold. I didn't see him on the scaffold." Now, that doesn't establish that he was told to not go on the scaffold, which, as an aside, it can't be sole proximate cause to be in the wrong area. Even if he wasn't allowed on the scaffold, that's comparative negligence at most. But as it goes to just general credibility, the Gonzalez affidavit is very interesting. He does not raise an issue as to the credibility of whether this accident occurred. If you look at it, he says he did not tell him to go up on the scaffold. He didn't see him on the scaffold. He didn't see the accident. He was there that day, Gonzalez. There's nothing in the affidavit at all that says, "I was there, and actually, at the time of the claimed accident, plaintiff was over on this other part of the site, and he was doing other work not on the scaffolding." There's nothing to contradict the plaintiff's version of events, and there are no admissible statements by the plaintiff contradicting his version of the accident and what happened. The medical records, as Your Honor noted, are completely inadmissible, and in any event, the statements in the records, it's the difference between, did the plaintiff say that a plank hit him or a piece of plywood hit him?
So it's really not germane to the care and treatment, is it?
It's not germane to the care and treatment, and even if the court were to consider it, the difference, I'm not even sure what the difference between plank and plywood is. The doctor wouldn't have, and either way, if it was a plank that fell down from the scaffold, it was a piece of plywood that fell down from the scaffold. Either way, that's something falling from the scaffold which should have been secured. And the cases are clear that even if there are two versions of an accident, if both of those are a statutory violation, then summary judgment is properly granted. So there's no evidence to raise an issue with plaintiff's credibility as to the happening of the accident, and it's a clear 240 sub 1 case. I would just quickly note, they didn't focus it too much on it here, but their argument that it was not required to be secured is just shown to be completely wrong by the record. All of the witnesses from the defendants and the third parties testified that it should be secured. They rely on a truncated quote on page 835 from the arsenal witness. The Arsenal witness had already testified that, that Arsenal required them to be secured. They secured them before releasing them. He went and described how they used a combination of wire and nails. And specifically on page 817, testifies that they should be secured while construction is ongoing. While they're, and even Mr. McIndoe of CCNY, he testified that they were meant to be moved, but once construction started, they were required to be tied down prior to accessing them. That's at page 687.
Counsel, thank you.
Thank you.
Plaintiff testified that on the date of the accident, the reason he was on the scaffold is that Mr. Gonzalez ordered him to do work on the scaffold. On page 2319, we have Mr. Gonzalez's affidavit. I never instructed, and he calls him Mr. Almonte because that's the name he was hired on for the job. He never instructed him to perform any work on the scaffold at the job site. So if that's not a contradiction, I don't know what is. Now, that's the first one. Again, this is a sole witness accident that the plaintiff that tells a story. Well, the day of the incident when he goes to the hospital, he says something hit his shoulder. He doesn't say anything about things falling or wood. He goes a few months later and he starts saying plywood hit his shoulder. Well, plywood's not on this scaffold. So where did this accident happen? I believe that goes to credibility and the fact that he was working under a different name for 7 to 8 months before they found out what his name was.
So, counsel, how do we deal with the testimony, with all the evidence that talks about the, whether it's plywood, whether it's planks, it should have been secured? At least 3 persons testified.
Yeah, but no one testified about plywood. There was no plywood on this scaffold. None, zero.
It should have been secured, certainly.
No, that's a plank. Okay, that's something different. But I'm saying in his medical records, he's saying that he was.
What's the
was
difference
struck by
between a
plywood.
plank and plywood? Because I don't know the difference. What is the difference between a plank and plywood?
Plank is, in this case, they were scaffold planking. They were 12 foot long, 8 inches
Doesn't it look
wide.
like plywood?
Plywood is a big piece of plywood.
You mean the dimensions are different? It's a board, isn't
It's a
plywood?
I wouldn't walk on plywood on a scaffold. I don't think that's something that you
Counsel,
would do.
both of those things are things that are required to be secured, right?
No, because there's no plywood on the scaffold. It's scaffold planking that has a thickness that you can walk on. Plywood, you don't have plywood on a scaffold.
Crux, does it matter whether it was plank or plywood? It says something fell. That's the crux of what he's saying.
Maybe.
Something fell, counsel.
And that's a credibility issue, I believe, based on this record, that should go to the
It's
jury.
not a
and the jury
credibility
can make
issue
that
because
decision.
we don't have anything in the record that
Refutes
refutes
it.
the plaintiff's claim of what happened.
Except
Except you're saying it didn't happen, but nobody else said they didn't.
Except that he
that they
wasn't
have
supposed
another
to.
way.
That he says the reason he's on the scaffold, he was directed by Mr. Gonzalez, and Mr. Gonzalez has given us an affidavit, said, I never told him to go on the scaffold.
What about our case law that, for example, Christo versus Board of Education, which indicates that you don't have a recalcitrant worker defense?
I'm not
Oh, okay.
suggesting that's what I'm going for. I'm saying there's a credibility issue, whether
You're
this
saying he's
accident
straight lying
happened
about
in the
everything.
manner
That's what you're
that the
saying,
plaintiff
counsel?
says.
You're just saying he's lying about everything.
I'm saying it's a question of fact that should go to the jury. A jury might think he is.
Thank you, counsel. Thank you all. Ortiz versus City of New York. You may begin. Thank you.
Good afternoon. May it please the court. Sean Schatzel of Lewis Brisbois on behalf of the defendants, appellants. This is also a labor law case. This also involves some issues about medical records and issues of fact. Long story short, we are asking this court to reverse so much of the trial court's order that denied that branch of our motion, which was to dismiss the plaintiff's 241-6 claim as premised upon section 23.2 23-1.1B44 of the Industrial Code, and we're asking this court to reverse so much of the order as granted the plaintiff's motion on the Labor Law 240 subsection 1 cause of action. So those are the two issues. I'd like to briefly address the 241-6 issue first. I think it's... Sure, okay. So I think this court can resolve, well, let me take a step back. Plaintiff testified that he was on a 12-foot A-frame ladder. He was welding a portion.
Also said that he had requested a harness on
He did say that, yes. And we're not, that's not, we're not, we don't have evidence to dispute that on this record at least. We're relying upon two pieces of evidence that we say creates a question of fact as to whether this accident happened in the way that he claimed it did. The first is our expert engineer's report, okay, which in so many words, and I'll get into the details, but in so many words, our expert says the plaintiff couldn't have been working on the ladder in the manner in which he claimed. Full stop.
Does it matter?
Yes.
Does it matter, like, what the expert said about the accident? And is the thing that's dispositive is the fact that he was on a ladder that fell, a ladder that collapsed.
Fair point, Your Honor.
Well, let me just add, unsecured ladder. It was unsecured.
It was an A-frame ladder, which, sure. I think it absolutely matters, Your Honor, and let me explain why. So, and it's based on the specific things that our engineer says. So this is at 648 of the record. There's two large paragraphs on that page. The bottom paragraph, he essentially says that if this gentleman had an A-frame ladder, 12-foot A-frame ladder, which is 6 foot wide on the bottom, in this area, okay, he wouldn't have been able to essentially reach the bracket in which he was welding, right? He was trying to weld a bracket against a wall, a vertical piece of metal against a wall, and he wouldn't have been able to reach it, so he couldn't have been working on the ladder in that way. He also points to...
So, counsel,
yes.
let me stop you.
Sure.
I thought he said he couldn't be working on the rung, the second rung, I think, for the top. But let's say if he was at a different rung, and we know that if you're in an accident, it could be a different rung. He didn't eliminate the possibility that he was on the ladder completely. He said he couldn't have been on the second to the top.
Yes, Your Honor. So that's what our expert says in that first paragraph on 648. He says if we're taking his testimony true about him reaching for the cord and whatever, you know, it just doesn't make any sense. He couldn't have been on the second rung. In that second, which we think that is important too, in that second paragraph, though, he talks about a different issue, which is that the plaintiff couldn't have been working on an A-frame ladder in the proper way, right? You're standing on an A-frame ladder, the ladder is in front of you, you're facing the object in which you're working on, and that the plaintiff couldn't have been doing this welding work if he had the A-frame ladder set up there. He would have
Let
been
me ask you this question. You know, what evidence did your client present to indicate that you provided, you know, plaintiff with, you know, an adequate safety device to protect him from falling? What evidence did you present?
Well, I'd say that it's not our burden to present it on plaintiff's motion. It's our burden to rebut what he said. And what we rebutted is, based on that expert engineer's testimony, essentially, if the plaintiff is not accurate about the type of ladder he was working on, the height he was working on, whether he was working on an open A-frame ladder at all, right? Which are questions that are raised by our engineer's affidavit, I submit. Okay, if the plaintiff's testimony is not accurate on those points, right? We're supposed to take his word for it that he fell from ladder. He could have been working on a different type of ladder. Let me give you an example. Okay, if he is not correct about the manner in which he was working on this ladder, right? You're supposed to be standing on an A-frame ladder facing it. He could have been standing on the other side of the ladder with the ladder behind him, which would have been an improper use of the ladder. He'd be sole proximate cause. Or he could have been improperly leaning the A-frame ladder. Like you have to have an A-frame ladder opened, locked position. Sometimes workers, you know, close it and lean it up against the wall like it's an extension ladder. If he was doing that,
Well, there was no evidence he was doing that.
there's not, Your Honor. But my point is, our expert.
We don't actually have any real evidence of anyone who was present,
No,
right?
an unwitnessed accident. You're right, Your Honor.
And all we have is a plaintiff's testimony, right? About
Essentially.
what occurred.
Yes.
Right, and in cases where we have in our cases in this department, where we have the plaintiff's testimony, isn't there a presumption of a violation where the ladder is alleged to have collapsed or malfunctioned for no apparent reason?
Correct. That is what this court's precedent says. And we're not disputing that precedent. We're saying, sure, the plaintiff's testimony can meet his prima facie burden, not disputing it. We're saying our engineer, by questioning whether he's telling the truth or misremembering the manner in which he was working on this ladder, that raises questions of fact entirely about how this accident occurred. And if he's not telling the truth or if he's misremembering the manner in which he was working on that ladder, the accident could have happened in an entirely different way, is the point. Okay, that is the point about the engineer, okay? Oh, by the way, the plaintiff doesn't respond to our engineer argument, doesn't mention it. His respondent's brief didn't address it below. Okay, so I think he's essentially conceded the points made by our engineer, and we think that creates a question of fact on 240. Okay, the plaintiff's brief focuses on the separate issue, which is the medical record, and which came up in the last case. Okay, so I'll address that too. If your honors don't agree with me about the engineer, okay, then we have to rely upon the medical record. Okay, so let me get to that briefly. The hospital record says, this is at I think it's 643 of the record, that the plaintiff told staff he felt pain after sliding down the ladder after misstepping. Okay, handful of issues raised with that. One, do the contents of that statement, if admissible, create a question of fact? 100% yes. Okay, the plaintiff cites case law that where people say they lost their balance, and this court has said that's not enough, because saying you lost your balance is not necessarily inconsistent with saying I lost my balance because the ladder kicked out, right?
How is this germane to care and treatment, whether he slipped down or he took a misstep and he fell and they're treating him?
We're not saying it is. So we're relying upon that's the business records exception, the hearsay rule. We separately have the prior inconsistent statement or admission against interest. I direct this court to, it's at page 12 of our brief, footnote 3, Prel de Cage versus Alps Realty from this court, which cites a Second Department decision, Coker. I'll quote it. A hearsay entry in a hospital record as to the happening of an injury is admissible at trial, even if not germane to treatment and diagnosis, if the entry is inconsistent. Essentially,
That is the Second Department case.
which this court has cited favorably. Okay, that's what I'm saying in that Prel de Cage decision. So if that is the law, okay, in this department, I think it is, then we don't have to show germane to diagnosis and treatment. If Your Honor disagree with me on that, we don't even argue that it is, so we'd have a huge problem, okay? But let's assume that we don't have to show that. We cite numerous decisions from this court. This is DeCambrino, Ellerby, Hamill, all from this court. In a letter we filed additional authority, Villalta, 2025 from the Second Department, that all say when some record says I misstepped, but the plaintiff says, oh.
So counsel,
yeah, sure.
the case law you cite is correct, but in the face of the only witness, the plaintiff, stating that the ladder shifted, there is no case law in the First Department that I know of that it then shifts the burden to you to show that the misstep was something more than that would occur absent the ladder shifting. So once the ladder shifts, it's your burden then to oppose.
And I would ask this court, for example, the Ellerby decision from this court from 2012, the testimony that created a question of fact was an individual who said that the plaintiff told him that he lost his footing, which is the same thing as a misstep. The DeCambrino decision, there was evidence that the plaintiff missed a step.
But there is no cases that I know of, respectfully, where the ladder shifts. If there's a misstep afterwards, it doesn't matter, because when the ladder shifts, it causes the person to fall. And if there's a misstep after the fact, our case law is that would constitute a violation of 240.
Well, I can say, Your Honor, as the plaintiff never testified, I missed a step after the ladder shifted, right? And I'd ask you to closely take a look at those cases I cited, because I think they're directly on point. The Hamill from 2010, there's a couple admissibility issues. My time is up. Can I briefly?
It is, and you can do that on rebuttal. Thank you.
Fair enough. Okay.
Good afternoon. May it please the court, Jonathan D. Moran for the plaintiff respondent. Your Honors.
How do you respond to this whole? I don't know if this is on or off. Okay. How do you respond to this the argument that their expert, the adversary's expert, basically opined that it couldn't have happened this way, so therefore there's some credibility issue?
Right. Well, so respectfully, I do not concede that creates a question of fact.
I didn't think you did.
The expert affirmation is really speculating that maybe it happened in a different way, but I would submit, Your Honors, that whether, he thinks he couldn't have been on the 10th rung, maybe he was on the 5th rung, there's no evidence to suggest that the ladder was misplaced, misused, or there was some kind of
issue here whether the ladder moved.
There is no issue that the ladder moved. The clear testimony, unrebutted by any evidence herein, is that the ladder tilted to the side and caused him to fall. So even if all of the evidence is considered irrespective of any admissibility issues, the labor law 240 sub 1 was violated under any version of events, and I think the case
And
that's
is that true whether he misstepped or something else caused the ladder to move?
it's true where if it was a misstep due to the movement of the ladder, then 240 sub 1 was violated. I would cite to this court's decisions in Lynn v. 100 Wall, I believe Merino, MERINO is also a case from this department where there's a statement given about a loss of balance or slip from a ladder, and then the more detailed testimony is elicited that that was occasioned by the failure of the safety device upon which the plaintiff.
Counsel, let's go to the 241-6 claim, because certainly this is an A-frame, so how is the industrial code provision even applicable here? Because that deals with leaning ladders, so.
Sure. So assuming that it's an A-frame ladder, I would agree that, and well, my client testified that it was an A-frame ladder. At the court below, the defendants were taking the position that it was an extension ladder. So to the extent that they're arguing 241 sub 6 should be dismissed, taking their argument at face value that it's an extension ladder, that industrial code would apply. I submit, Your Honors, my client testified that it's an A-frame ladder. We don't dispute that it was an A-frame ladder. And 241-6 largely, it becomes academic were this court to agree with my position that 240 sub 1 was violated, and I submit that it was.
Your client testified that the ladder was fully open, is that correct?
I believe that's correct, Your Honor.
It couldn't be a leaning ladder if it was fully open.
I do not dispute that it was an A-frame, fully open ladder, Your Honor. Unless the court, unless the court has any other questions, I'll rest on my brief.
Thank you.
Thank you, Your Honors.
Briefly, Your Honors.
Just give me a minute. Let me reset the clock and start it. Please begin.
Briefly, Your Honors.
In regards to the industrial code, what is your position? Is it an A-frame or is it a leaning ladder?
We did not take the position that it was a leaning ladder below. There's a line in our, I think it was in our expert's affidavit, where he's quoting an accident report that said something
So
about.
the 241-6 really doesn't seem to be an issue
Absolutely.
here.
I think Your Honors get the point on that.
So let's,
Okay.
I think we get the point on that, so.
So let me say what I need to on the admissibility. First of all, again, I'd ask Your Honor to take a look at those cases we cite about missteps. I think they're 100% on point if you can consider the record. And the points on that are this. There's 2 points. One, they say the records were not certified. Okay, if you take a look at, I think it's 640 of the record, there's a letter from an individual essentially saying, the Health Information Management Office of Montefiore Hospital, essentially saying, we're responding to your request for records. Here are the records we have on this patient. Okay, we think that does the work for CPLR 4518C.
You're saying that certifies the records?
Yes, and we say that for this reason. A 4518C certification has to satisfy the facts in 4518, which is made in the regular course of business, all those familiar factors. And we don't think it's a magic words test. We think it's do the facts in the certification with the overall context, establish it, and it's the job of a hospital to create records on behalf of their patients. We have a letter here from an individual signing it saying, these are our records. Briefly on the translator, they say the information, the record clearly states the information came from the patient, and it says it was translated, and it has the translator ID. We point this court to the hospital's website, which talks about how it uses professional translators who abide by a code, they're paid by the hour, all of these things. And we think that does the work.
Counsel, I think we're conflating two issues.
Sure.
There's something called authentication, which is the business record rule, and the other one is whether or not it's admissible. It's not admissible even on motion for summary judgment, unless it's germane to treatment, and that's the case law that I'm familiar with.
Your Honor, if that is the court's conclusion, then we lose as it relates to the medical record, and we have to rely solely upon the engineer. But I would just ask, and my time is up, I'd ask this court to take a look at that Preldicage case at page 12, footnote 3 of our brief, citing Coker from the Second Department. I think that's good law in this department. Thank you, Your Honors.
Thank you. Rouse v. Ahmed.
Good afternoon. May it please the court. Samantha Quinn for defendants appellants Dr. Ahmed and St. Barnabas Hospital. I would like to focus the court on the issue of proximate cause of this patient's death. I submit that the defendant's evidence with respect to proximate cause of her death was credible and was entirely unrefuted by the plaintiff's expert. Our expert at page 57 of the record states the following: St. Barnabas Hospital and Dr. Ahmed did not cause Ms. Rao's heart attack. They did not cause her blood vessels to be occluded. They did not cause her to
Well, I read that. I think we all read that. But I have one question. So it seems that your expert read some records purportedly that indicated that there was only one ulcer that this woman had. When the records, well, that's what it looked like in this affidavit, when the records seemed like the situation was that there were numerous sacral ulcers and others that she did not mention.
Respectfully, Your Honor, what she stated was that there was one ulcer that was caused by pressure, and that there were other wounds which were caused by other things, such as the patient's vascular compromise. And at page 20 of our opening brief, we actually cite from one of the assessment and cares notes, and there are about 2,000 pages of these notes that we have included, which document the turning and positioning, which document the care this patient had. But specifically at page 20 to 21, they quote from their lists: wound, site left heel, wound site right heel, wound right lateral lower leg, wound right foot between small fourth toe, fifth toe, and then pressure ulcer, sacrum, pressure ulcer, location sacral spine. And what Dr. Wolf-Klein stated, and in my opinion, the lower court erred in discounting her entire opinion based on this, was that based upon all of the notations in the medical record, only one of these injuries was pressure related. In fact, most of the patient's injuries stem.
Didn't the plaintiff make allegations in this case that the decedents, that some of the decedents on other injuries were also pressure ulcers, and that your expert never really dealt with it? They said, we found one sacral ulcer and that was it, when the plaintiff's allegations were very different, and you never really then went on to explain or to prove that, in fact, there was the turning that was required by the records every few hours.
Again, respectfully, even Judge Frischman pointed out that the plaintiff's allegations that turning and positioning was not documented were baseless, and this was at page 8 of the record in his decision.
Well, okay, but what about in the record? I mean, I read
In the
his
record,
decision.
as I mentioned, the assessment and cares notes from pages, I believe, 318 through 2,300 and something, daily document that this was done. Now, the plaintiff takes the position that this was a plan and not documentation of what happened, but the nurse Perwet, who testified at 2770 to 71, I believe, that where they would have documented turning and positioning was in these assessment and cares notes. And if you read them, they're all different.
Well, I think what the plaintiff's expert essentially was saying is that it was what was in the records, they were just generalized sort of notations about potential turning and moving, but not actually, not anything specific that it was actually done.
I disagree. It was documenting that it was done. It was documenting.
But see, the disagreement is what creates the question of fact.
No, Your Honor, there was documentation that it was done. It was not documented with times every 2 hours, and that is what plaintiff's expert is saying was the failure here. But there's no requirement that an acute care facility treating a critically ill patient like this document in a log like a nursing home. That is absolutely not required. And the testimony is that the way they documented this was in this manner by shift. And it's noted that we turned and positioned her. The plaintiff tries to say that the notes are that she is to be turned in position. That's nowhere in the record.
Counsel, I know that the plaintiff is saying that the other ulcers, the buttocks, the right lower extremity, that the notations in the records, mistakenly, I should say, mistakenly indicate wounds rather than pressure ulcers. And so my question is, how do you reconcile that argument with the testimony from Dr. Ahmed and even the nurse that says that those were pressure ulcers, not wounds?
Well, Your Honor, I believe that the doctor and the nurse were using generalized terms, and I would ask that the court refer to the thousands of pages of contemporaneous medical records, which are more specific about the cause. But what I would like to say, I see my time is running low. Back to the wrongful death issue, the plaintiff's expert completely fails to address the repeated failure of the family to consent to life-saving treatment over the course of 10 months. It was first noted November 23rd of 2019 that the right lower extremity is unsalvageable, that she needs an above-the-knee amputation, that the failure to do this is going to result in chronic infection that's going to worsen. The necrosis will grow up, and it will lead to multisystem organ failure. And in fact, the plaintiff's expert's commentary about the death is literally one sentence at record at 2564. It's completely insufficient, and I would ask that the court consider that issue. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Carl Tegmeyer of Sanaki, Newman, and Turd on behalf of the plaintiff respondent, the estate of Marie Rouse. So initially, I'll just note that the trial court actually found that the defendants did not make a prima facie showing of entitlement to summary judgment as a matter of law. That was the finding, and then secondarily, even if they had made that finding, that there were issues of fact, and then the court fully addressed the opinions of the plaintiff respondent's expert. With respect to the failure to make a prima facie showing, it's important because Dr. Wolf Klein, defendant's expert, said that the only pressure ulcer was the sacrum. In that regard, Dr. Wolf Klein said that the pressure injury there was unavoidable, and that was the standard. Despite all their best efforts, it was unavoidable, it was going to happen anyway. That was self-contradictory with the own medical records submitted by the defendant and the defendant's own real-time evaluations of the plaintiff's decedent on the Braden scale, which Dr. Wolf Klein doesn't even mention once in her affirmation, nor does Dr. Wolf Klein cite to any of the evidence in the record. There's no pinpoint citations of pages. Dr. Wolf Klein just makes conclusory general assertions as to what was done, what was not. But going back to the Braden assessments, the patient was routinely evaluated as a moderate risk and at times a high risk for skin breakdown in the sacrum, never a very high risk, which is the most serious evaluation. And you would think a patient who has an unavoidable risk of skin breakdown would be at least once, at least on one day, a very high risk for skin breakdown. With respect to the lower extremity ulcers, we're talking about the bilateral heels, the left and right heel, and the right lateral leg, the outside of the right lower extremity. Dr. Wolf Klein, again, disregards, there's documentation in the medical record where it's noted as a pressure ulcer, appendix page 488, ignores the deposition testimony, as the court noted, of Dr. Ahmed, who testified it was a pressure ulcer, of Nurse Poirier, who testified that these were pressure ulcers. So that was the court's initial finding. With respect,
What about the discussion we were having with your adversary about the turning and whether it was just in the record to be done every 2 or 4 hours, or we're doing it, and the amount of documentation and whether it was adequate as it was in the record?
right. So in the record, the turning and positioning is purportedly documented in the assessment and care section, where it states a number of things that are copy and pasted for each note every 12 hours throughout the course of the more than year-long admission. And it states, draw sheet or mechanical lift used to move patient. / friction and shear limited / turned and repositioned every 2 hours. That it's their position that that note, every 12 hours in the record,
Confirms that they did it
supposed
every
to
2
confirm it
hours.
was every 2 hours. Our expert addressed this specifically. He stated that based on continuity of care and based on his experience in having treated patients and developing plans to avoid these pressure ulcers, you need to know the time when moving positioning was done, what position the person was moved to, left, right, off left, off right, if there was offloading devices used, who actually did it, and when, because you don't have the same people treating someone in a hospital. There's numerous people that come in and out of the care. They need to know, when was this person last turned in position? You can't just hit a button at the end of a 12-hour shift and say, oh yeah, we did it every 2 hours. He says that's deficient. That created an issue of fact in the event they did make a prima facie showing. There's also other departures from the standard of care. The failure to order a specialty mattress, the failure to document the use of offloading devices throughout. The specialty air mattress wasn't used until after it was documented that there was two skin tears on the sacrum of the lower back. After that, there was the initial injury on the lower extremity.
How do you deal with your adversary's point that the family's failure to engage in life-saving procedures or to accept those is what the expert says caused her demise?
So again, my expert's a board-certified vascular surgeon who addressed this with more than one sentence, and he went into the proximate cause of what developed first as dry gangrene to the toes and the sepsis that developed and everything else. With respect as a matter of law, the refusal by the daughter to agree to do an amputation would go to a mitigation of damages or to comparative fault. That's a jury issue. With respect to the medicine and what the doctor said, the defendants are responsible for all of the injuries that they cause and everything that flows therefrom. So therefore, they deprive this patient of the substantial possibility of a better outcome, more favorable prognosis, including avoiding the wrongful death that she suffered.
And just very briefly, you know, with respect to the lack of informed consent, you didn't challenge that below, nor did you do on appeal, correct?
Correct, Your Honor.
All right, thank you.
All right, thank you.
Briefly, I respectfully disagree that plaintiff's expert addressed the patient's wrongful death in more than one sentence. It is at 2564. It's my further opinion that defendants' departures from good and accepted medical practice deprived Ms. Rouse of the substantial possibility of a better outcome and more favorable prognosis, including the total avoidance of skin breakdown and the total avoidance of her wrongful death. It's detailed in our brief that this is an entirely specious conclusion and it's unsupported. Meanwhile, the Dr. Wolfklein's references were, the attorney affirmation had the citations, they were mirrored in what she had written. But as early as November of 2019, this is a note from vascular surgery on November 23rd. Right leg is not salvageable. Patient will need non-emergent right lower extremity, AKA in view of her being bedbound and her RLE contracture. Spoke to the daughter, Myrna Rouse, via telephone regarding amputation, risks, benefits, complications, and she refused. She was informed that the foot infection may worsen and can lead to vital organ failure and death if not treated. However, she continues to refuse amputation for the patient. Continue local wound care, continue antibiotics, although it is very unlikely antibiotics will get to the infection due to the compromised blood circulation. Now, the only reference to the patient's, the family's repeated, and that is repeated multiple times throughout the record, it's documented. The only reference to that in the plaintiff's expert's affirmation was at 2555. One sentence, a resident explained the need on February 8th, so this is 3 months later, the need for amputation to Ms. Rouse's daughter, Myrna, but she did not consent to the amputation and alternatively decided to accept medical therapies with antibiotics and wound care. That's completely inaccurate, and based upon this alone and the failure to acknowledge the family's refusal to consent to life-saving treatment, I believe that the wrongful death cause of action should be dismissed.
Thank you.
Thank you.
People v. Ruffin.
Good afternoon. May it please the court, on behalf of Mr. Ruffin, Luz Beato. In this case, 8 officers stormed a courtyard on the pretext that individuals were there after hours. They were not responding to a 911 call. They were not responding to an incident. Body-worn camera shows an officer walking up to a young man.
Beato, let's address the waiver. What is not valid about the waiver of the right to appeal here?
Yes, Your Honor. In People versus Billingsley, the Court of Appeals held that it was impermissible for the plea court to tell the defendant, if you went to trial and were convicted, you have a right to appeal. But when you plead guilty, you waive your right to appeal. And the reason that that particular colloquy was found, made the waiver invalid, was because it was misleading. It led the defendant to believe that the only way that you get an appeal is if you go to trial and you raise those issues or the decisions that the court made below.
The court here read the model colloquy on waivers of right to appeal, correct?
No,
And
Your Honor.
Explained. You said no?
No, Your Honor. There was a significant deviation as it pertains to this point. So here the plea court told Mr. Ruffin, if he took his case to trial and was convicted by a jury, he could appeal any decision made by the judge. However,
that's taking it out of context, right? What it actually says is the right to appeal is the right to have a court above my level, known as the appellate court, review decisions made at my level. For example, if you take these cases to trial, and then what you were going to read is what's spoken. So the court was using that as an example to explain its prior broader sentence that the right to appeal would include any decision made at that level, not only at trial.
yes, Your Honor. So the argument that I'm trying to make is that the plea colloquy was misleading and that it gave Mr. Ruffin the impression that the only way you take an appeal is if you go to trial.
And you're saying that the impression that the defendant got was based on the example that the court gave.
Well, the plea court's colloquy deviated from the model colloquy in one very important regards. The model colloquy states, a defendant ordinarily retains the right to appeal even after pleading guilty. And then it goes on to say that the waiver of appeal is separate and distinct from the waiver of trial and other rights. In this case, however, as a condition of the plea agreement, you're being asked to waive your right to appeal. The plea court's colloquy was misleading because it did not specifically explain to Mr. Ruffin that you can take an appeal if you go to trial. You can also take an appeal if you plead guilty. However, as part of this agreement, you're forfeiting your right to an appeal. So in that way, it's misleading because it gives the impression that
Didn't the judge also say it was separate? So how would there be a miscommunication? Because I see the transcript, and I believe you are being asked to waive your right to appeal. Your right to appeal is separate. He doesn't use the word distinct, which is part of the model. So how would you confuse that?
I think because we know what we're looking for, is that we can read this colloquy and sort of, okay, they said the right to appeal is separate and distinct. It says if you go to trial, you can take an appeal. As a result, but it doesn't specifically say if you plead guilty, ordinarily you retain the right to appeal. It sort of extinguishes the right that one has after taking an appeal, after pleading guilty to take an appeal. It sort of is misleading because it leads Mr. Ruffin to believe that the waiver is a consequence of the guilty plea.
Wasn't that covered by the written waiver?
Well, the written
Exactly
waiver,
what you're saying now, it's covered by the written waiver. I understand that I would ordinarily retain my right to appeal, even after pleading guilty.
but the written waiver is not always a remedy to misleading plea colloquy. But I see that my time is already running low, so I'd love to address the suppression arguments in this case. So, as I was mentioning in this,
Before you address that suppression argument, if we find that this is a valid waiver, then we don't even get to your suppression argument, right?
absolutely, Your Honor, and if there's anything else about the waiver that I have.
No.
Okay, great. So in this is aggressive show of force, which led to all officers in this case being investigated by internal affairs due to complaints for civilians. The officers stormed this courtyard on the pretext of trespassing. However, you see,
Pretext. It was late at night, and the courtyard is closed after a certain hour, correct?
right, but as the lower court found below,
What the lower court found below was that you couldn't find a trespass necessarily on this record because only one entrance had the sign about the hours and not the other.
that is correct, Your Honor.
It doesn't mean that it's pretextual, right?
Well, you know that it,
Beyond a reasonable doubt is different.
well, the body-worn camera sort of evinces that this is pretextual because you see Officer Abreu walking right up to an individual that has his hand on his lap and goes right into his pockets. So we know that they're not here to investigate trespass. We know that they're here to do illegal searches. And trespass plus innocuous conduct.
I mean, that's a huge leap between coming into the park in basically the wee hours of the morning when the park's supposed to be closed and searching someone. To say that the purpose of being there was an illegal search.
Well, I do think that if you go to a courtyard to investigate trespass, but what you're doing is going right into somebody's pockets.
That's more than that, counsel. Wasn't there the knowledge that the officers knew that there was that the defendant was wanted for something relating to a gun, and then there was an indication that when the officers approached, the defendant put his hand by his waist, indicative of holding something in his waistband, and then took flight.
So, Your Honor, Detective Warner, who had knowledge of this intelligence flyer, was the 5th or the 6th officer to walk into the courtyard. The officer who initiated pursuit, Officer Ruiz, there was no testimony that Detective Warner communicated to the officer who initiated pursuit knowledge of this flyer. So we know that this flyer existed after the illegal.
Or the pursuing officer, you're saying, did not at the
There's right that Detective Warner, who testified, never testified that he relayed to Officer Ruiz knowledge of this flyer. And I'd love to.
But we also know that it's 1 o'clock in the morning. It's an area that is known for drug and gun activity, and the defendant's movements, with the hand, sort of suggested that there was something there.
Yes,
possibly a weapon.
Yes, Your Honor, I do recognize that the officers made blanket allegations that this is a high crime area based on prior arrest, but high crime plus innocuous conduct does not get us reasonable suspicion. And the innocuous conduct, the testimony was a tap on the waistband. A tap on the waistband, I've got nothing, and he took flight. It was not holding a waistband indicating holding a heart, like a heavy object. It was not a bulge. It's simply a tap. And I would submit to this court that Mr. Ruffin has a double inference can be made from this illegal search that's being conducted around him. His actions are indicative of a person who is afraid of police conduct and is also afraid of an illegal search that's being conducted. So, a tap on the waistband is a far cry from an L-shaped bulge or holding the waistband as we're moving.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. Russell Spivak for the people. The defendant, Taishik Ruffin, validly waived his right to appeal, both orally and in writing, as the panel has already discussed previously with my colleague. Moreover, the officers, in the people's view, acted reasonably and pursuant to their authority under DeBoer at all times, given the numerous factors that have already been discussed that give rise to suspicion.
Counsel, your adversary says that the officer that had the knowledge with regards to the iCard or whatever it is that it's called, did not relay that information to the pursuing officer. Does that make a difference under the facts of this case?
No, Your Honor, it doesn't. The officer...
you concede that point, by the way?
Yes, we do, Your Honor.
Okay.
It is certainly uncontested that the officer, I believe it was Detective Warner, who had knowledge of the iCard, did not say anything to his fellow officers. But that certainly doesn't vitiate the notion that each of the other factors, as has been discussed, the time, the predicate factor of potential criminal trespass, the prior to engaging, raising hands to say, I'm not, I don't got nothing, I believe was what was quoted. Each
In
of
fact, the
these,
police didn't even ask the defendant anything.
Correct.
He volunteered with that.
Correct, Your Honor.
And that was after, you know, some movement around the waistband and the groin area.
Correct, Your Honor. So finally, just on the sentencing argument that my colleague had put in the brief, the defendant had failed to preserve that, but even if it could be raised now, there are no mitigating factors that would suggest any part of the sentence should be modified. And pending any questions, the people would ask that you affirm. Thank you.
Just a minor clarification.
Just give me a minute. Thank you. Please begin. Thank you.
Just a minor clarification. It was an intelligence flyer, not an iCard. I appreciate.
I wasn't sure what it was.
I always appreciate that that's probably a distinction without difference in this context. Also, responding to the argument that this court can't reach the sentencing, can't run the sentences concurrent because it wasn't preserved below, this court, in the interest of justice, can always reach a sentencing.
To run the sentence concurrent, the sentencing court would have had to have found some sort of mitigation, right?
Well, I think the record is, well, it is true, Your Honor, that because this was a negotiated plea, the attorney did not put on the record mitigating facts as you would if you are.
But the court would have had to have made its own independent determination of mitigation as per the statute and make specific findings, right?
Well,
to run it consecutive based on, do you want me to get the penal law section for you?
No, Your Honor. I understand the point that you're trying to make. And my response to Your Honor is that in order to run the sentences concurrent, the sentencing court would have had to hear mitigating factors as to the manner in which the crime was committed.
Right.
But because there are suppression hearings that were conducted in this case and in the other case, we know the manner in which the weapon was possessed. We know that it was not used or displayed. We know the circumstances of how the weapon was retrieved. So the record is preserved as to the manner in which the crime was committed. So if Your Honors are inclined to run it concurrently, you can use your interest of justice jurisdiction, which is immune to preservation.
What would incline us to do that given the facts of this case, which is that the defendant was out on bail for possessing one firearm and maybe about 2 months later was arrested again for possessing another firearm?
Well, Your Honor, I think that there are mitigating factors. I would submit to Your Honor that this whole interaction was a Fourth Amendment violation. And also the fact that the weapon was not used nor displayed. Mr. Ruffin was working. I believe he was a para specialist for the Department of Education. So I do believe that there's enough information should Your Honor want to reduce your sentence or run it concurrently in the event that you do not suppress due to the Fourth Amendment violation. Thank you.
Thank you. Cochancella, Sutton Place South.
May it please the court, Jessica Smith for defendants appellants. Plaintiff's accident here was caused by an ordinary hazard of the workplace and not an elevation hazard. As a result, the defendant should have been granted summary judgment on plaintiff's labor law 240 claim. Here, plaintiff testified only to one thing causing his fall, and that was the presence of wetness on the set of stairs. He did not mention any other contributing factors. Because of this case falls into the Court of Appeals case of Nicometti, which we represent is controlling. There's no device here that could have prevented the plaintiff from falling and slipping on water, which is what's necessary in order to prove a Labor Law 241.
What about our case from 2024, De Silva, where also a plaintiff was walking down a permanent staircase, and they said that that was a 240 subsection 1 violation because he was manually handling this. I mean, he was walking down these stairs carrying allegedly a 70 to 75 pound what looked, because we all saw the surveillance tape, which looked somewhat unwieldy piece of plywood that, you know, it was very hard to balance as he was walking down the stairs. So doesn't that sort of fit very much into the box created by the De Silva case where we did find 241?
So De Silva is different. I'm sorry, were you finished? Okay. De Silva was different because you're right. He is carrying this item on the stairs with a partner. But what's unique about that case, and we don't have here, is they're trying to negotiate around this pole. And they try multiple times. They're failing. He's hitting the pole. And he actually testifies that that's what caused him to slip.
In that case, yeah. Right.
Yeah, slip on concrete dust. So in that case, the position is really that there should have been a device to help them carry that up the stairs, because that is the direct link between his slipping and falling and the Labor Law 240 device. We don't have that here because plaintiff didn't testify.
Isn't the direct link really like a gravitational force that propels the individual forward based on the elevation?
Well, it's actually interesting that you bring that up, and I'm glad because I was just going there. So plaintiff was asked that specific question at his deposition, and he said, no, the stairs were wet. So plaintiff himself, which we have to accept his testimony, he's the one who's telling us why he fell. And he's saying, no, that wasn't it. It was the water. It was only the water, which takes this out of the context of the De Silva, and there are a couple of other similar cases. This isn't a failure of a Labor Law 240 device. This is a slip and fall in water. This is Nicomeni. So that's why this case is, we should have dismissal here, and it wasn't in De Silva, and the court relied on De Silva, which is how they reached their conclusion. And in fact, they do cite this idea that there was an unwieldy piece of sheetrock that he was carrying in the lower court's decision, but that's based upon their own speculation because they're essentially ignoring what plaintiff himself has told us was the cause of his fall, which we have to accept.
Or looking at the surveillance video, right?
Right.
That also tells us what was potentially the cause of the fall.
Well, the surveillance video is actually interesting because, as you know, in our brief, we're saying that there's actually no water on the stairs. There's no indication there was any water, so there's nothing to actually prompt plaintiff's fall in the manner that he claims. But you can also see
It certainly looks like the plaintiff is having difficulty. You know, he's holding, you know, that material with, you know, both hands, unable to use the handrail, and seem that he's, you know, trying to negotiate his balance, having some difficulty going down the stairs.
Plaintiff was free to tell us that was what caused his fall, and he had every opportunity to do so, and was asked multiple times, and he did not. He kept saying it was the water. So I think we have to abide by plaintiff's own testimony. And, you know, regardless, there's no indication there's water on the stairs.
Well, what about the testimony that there was somebody from the building who was watering down, you know, wetting the outside area, cleaning it up, and with the workers walking back in and out with the plywood or with sheetrock, that they were tracking the water onto the stairs, even though I couldn't personally see it on this videotape, but it was also possibly the angle.
Are you asking with respect to the other labor law claim?
Well, I'm saying, no, with respect to, I mean, there was some testimony that there was water being sprayed right outside the entrance way, that there was somebody from the building.
Yeah, there is it was actually somebody from Douglas Elliman, so it wasn't, you know, just to make that minor distinction. There is testimony to that effect, and plaintiff was saying essentially that that was ongoing at the time. There's also testimony from somebody from the building that says that that doesn't actually cause water to accumulate on the sidewalk. Nevertheless, you know, when we raise this point with respect to Labor Law 200 and common law negligence, there's no indication of actually when this condition would have been created, because plaintiff says it's created by workers essentially walking down the stairs, and the worker actually goes down the stairs right before him. And it's also important for, the entirety of, the credibility of this claim there was water present is that you see that worker walking before him, no issues. Plaintiff had gone up and down these stairs all morning, numerous times carrying sheetrock, no issues. And then we see here that at the 29-second mark in the video, plaintiff changes the way he descends the stairs. And it's only after that that he has the misstep. In addition to that point, we also have the medical records where it relayed to medical providers on the day of the accident that he missed a step. So all of these factors together weigh against the finding of 240 liability. Plaintiff certainly should not have been granted summary judgment on that claim.
Thank you.
Good morning. Good afternoon, judges. Sagar Chada, Liakis Law for plaintiff respondent Wilson Chacho Bolivar Cochancela. Plaintiff's respondent's position is that Justice Bluth got this decision 100% correct. First and foremost, the permanent staircase is a safety device that's long-standing.
Can I interrupt you? What about counsel's indication or argument that during your client's deposition that he denied that it was sort of the force of gravity or whatever that was made him fall and that rather it was water on the stairs?
Well, Your Honor, my response to that is, first and foremost, the plaintiff testifies that he's carrying this 8-foot-long sheetrock board down these stairs, and that they were tracking in water from the maintenance worker that created that condition by watering the stairway. The sidewalk outside. Then you see him on the video, and Justice Bluth correctly says, I can't, there's a portion of the sheetrock board that's blocking his right foot. So we don't know if he slips at that point, but you do see him clearly lose his balance and then fall all the way down to the basement landing below. So the plaintiff correctly testified that he slipped and fell, and then he loses his balance and then falls down the staircase. The good thing about this case, thankfully, is that we have video. So we don't necessarily need the plaintiff's testimony. The video clearly shows that it's a gravity-related hazard under the First Department, not just De Silva v. Toll GC, but also in Solarte v. Brearley School, which the First Department ruled in 2025, denying defendant's motion as to 240, specifically stating that a permanent staircase is a safety device. In Oliveira, which Justice Bluth also cited, in that case, the plaintiff lost his balance and then fell down a set of stairs, which is identical to this case. So they cite to Nicometti. Nicometti relates to an unrelated hazard. The plaintiff was on stilts in Nicometti, and the First Department said that the stilts were an adequate safety device, and he slipped on ice. Here, what you have is the inadequacy of the safety device for the work that was being performed. That is the inadequacy of the staircase. The plaintiff in this scenario, they could have done anything. They could have put scissor lifts. They could have put a Baker scaffold going to the level of the street down to the sub-level below. They could have had a scissor lift allowing workers to access the street level and the bottom level. They could have used ropes, slings, pulleys to bundle the sheetrock boards together and lower them down to the basement level. They did none of that. Instead, they chose to have these workers, one by one, bring down these 8-foot-long sheetrock boards, and you can clearly see the plaintiff is having difficulty bringing this down on his own. He then loses his balance and falls. It's a straight 240 violation. That's exactly what Justice Bluth opined upon, and more importantly, it's identical to De Silva. What's fatal to their argument is they cite De Silva in their papers, but De Silva...
It's irrelevant that the plaintiff himself did not say that it was the falling down the steps or the gravitational pull or that he lost his balance, and instead said that he slipped on water. It doesn't matter in terms of the analysis on summary judgment here?
Well, what the plaintiff testified to, Your Honor, is that he says that he slipped on the water and then fell down the stairs. And he doesn't necessarily have to say, the force of gravity caused me to do that. Clearly, if you're traversing down these stairs and then you fall to the landing below, and in this case you have video evidence showing it, it's a gravity-related hazard. And then there is a direct link between the gravity-related differential, and they also tell you, on one hand, she's saying we have to abide by the plaintiff's testimony that the stairs was wet. Then the next sentence is, there is no indication that the stairs were wet. So which is it? Because clearly, it does not matter under 240 whether the stairs were wet or whether he lost his balance and then fell down. The safety device, which was the stairs, were inadequate for the work being performed. That goes to Narducci under the Court of Appeals, and that's exactly what Justice Bluth was referring to when she cited Conlon and also Oliveira, which both cite to Narducci. In regard to the 241-6 claim, Justice Bluth correctly said that there was a question of fact, and denied their motion because she says, I can't give you 1.7D. I can't see from the video if the stairs are wet or not. But we have testimony that creates a question of fact because their own maintenance worker testified that they would water the stairs down, water the street level down every single day. And then Mr. Cochancela says that the workers were traversing the street level and bringing water into the stairs. In regard to 200, their argument is fatal to their argument is the fact that they don't proffer any evidence to show when is the last time that stairway was inspected for the dangerous condition which is alleged, which is water on the stairs. Failure to do that automatically will result in the First Department of a denial of a summary judgment motion to dismiss the 200 claim. And if there are no further questions by the court, I'll rest on the brief.
Thank you.
Thank you.
You may begin.
Thank you. So obviously, we all know that not every fall down the stairs is going to be Labor Law 240, which if you accept plaintiff's argument is the foregone conclusion. Two, I want to point out the specific testimony I was referring to just to make sure there's no ambiguity based upon plaintiff's argument. Did your foot slip because the weight of the sheetrock was propelling you down the stairs? Answer, the floor was wet. You claim that the steps were wet. Is that your testimony? Yes. Then later, he denied losing grip on the sheetrock before falling. All this together tells us that plaintiff did not see the failure of anyone to provide him a device to carry the sheetrock down the stairs as a proximate cause of his fall. Then just moving on to the issue of the presence of the water on the stairs, we're arguing in the alternative here. We're saying that there is no presence indicated in the video, but however, if there is, then the presence of water is the only thing that makes these stairs allegedly defective if they're a safety device. So if there is a dispute, if we can't tell from the video, if it's unclear, as frankly the motion court said below, then that is a clear issue of fact that precludes a finding of summary judgment on Labor Law 240. So therefore, at the very least, the order granting plaintiff summary judgment should be reversed and the jury should get a chance to see the video and assess it for themselves.
Isn't it true that the plaintiff requested a hoist or some other mechanism in order to do this?
No, that's not in the record. I don't have any indication of that.
That's not the case?
No, there's some testimony that one of the witnesses were asked, like, could there have been a crane installed to bring it from the outside? And someone did admit, in theory, a crane could have been installed.
That's what I was talking.
Yeah.
Some safety device was requested, correct?
No, it wasn't requested. It was said that it was possible when the defense witness for Clark was asked whether it was possible. And he said, yes, it is possible. There was no request by plaintiff for a safety device. Just briefly on 200. So here, this watering process, based on the testimony, would take approximately 30 to 40 minutes. And plaintiff testified that it was still ongoing. This, from the testimony, was the last area that would be watered and washed. So based upon that math and the fact that workers were still continuously walking down the stairs, it just wouldn't have been sufficient time as a matter of law for there to have been any notice of this defect. And I see my time's up. Thank you.
Thank you.
People v. Rivera.
Good afternoon. Karen Brill with the Office of the Appellate Defender on behalf of William Rivera. Mr. Rivera's trial went forward seconds after defense counsel was appointed to the case when he said he had no idea what the defense was. That was a constructive deprivation of Mr. Rivera's right to counsel and a violation of his right to meaningful representation, and his conviction must be reversed. What the Supreme Court has instructed in cases like United States v. Chronic is that if an attorney is assigned to a case in circumstances where it was very likely he could not perform the duties of counsel, that's to investigate, review, and prepare before trial, there is a deprivation of the right to counsel without any consideration of prejudice under Strickland. This is that case. Mr. Puglisi had never heard of this case before the day of trial. On the day of trial, he was appointed to be Mr. Rivera's legal advisor, and he remained only Mr. Rivera's legal advisor through the prosecution's opening statement and through the lunch break. And it's only after lunch that the court says, actually, you're gonna go forward as counsel. And Mr. Puglisi says, I don't know the defense, and he also objects and asks to be relieved. And the court has the prosecution put on its entire case. Mr. Pugliese later filed an affirmation with his motion to set aside the verdict, in which he confirmed that he did not have specific details about the case during the prosecution's presentation. He didn't know information to challenge the evidence during the time. The record is crystal clear that he had no time or notice to fulfill the basic duties of counsel, which are to prepare and investigate before a trial begins.
You know, what, if any, role did your client play? Because certainly I believe he refused to meet with counsel, right?
Yes, and I actually think that the trial court correctly understood the consequences of Mr. Rivera's behavior, insofar as what the court said was that because Mr. Rivera didn't come to court, he lost the right to represent himself. We're not contesting that. He lost the right to be present, and he lost the right to consult with counsel. That's all true, but he did not lose the right to counsel. And so what Mr. Pugliese still had to do was read all of the case materials. In this case, Mr. Rivera had testified in the grand jury. He had also written to the court several letters of where he described his account of the incident, basically previewing his trial testimony almost verbatim. If Pugliese had had time to read those materials, he would have known the defense without
Did
ever...
he say that he needed more time? Did he say, you know, I need more time, I'm not prepared?
He did not, and I think that was a massive deficiency by him and a basis for finding that he did not provide meaningful representation, because there is no possible reasonable justification for going forward when you are saying you don't know what the defense is.
You know, how do you address me talking to the mic, you know, how do you address the fact that I believe counsel said that, you know, the case really wasn't complicated, right? You just have, you know, the two counts, the grand jury testimony was about what, 20 pages, so, you know, what's your response to that?
I think that a case being...
You know, two witnesses, of course.
Yeah, I think a case where the allegations are simple does not mean that counsel's job is easy. This was a credibility contest. Mr. Rivera disagreed about the basic facts of each of the three incidents here. And so to put on a credibility contest, defense counsel would have needed time to investigate the complainant. That takes time, looking into prior bad acts, looking for a motive to lie, looking through his prior statements for any impeaching contradictions. It inherently takes time, and Pugliese had literally no time. And that is just not what lives up to the right to counsel. The facts here are incredibly close to those in Powell versus Alabama, which the Supreme Court has said is basically the prototype for this kind of error. That, like this case, was a same-day appointment. The attorney there, like the attorney here, admitted he wasn't prepared, asked to be relieved.
Does it make a difference that defense counsel here was appointed as advisor and not as counsel because the defendant was granted his wish to go pro se?
I think it makes actually a difference in that he had even less time to prepare as counsel than even that lunch break would have otherwise given him. During the lunch break, he thought he was the legal advisor. So even during that, the only time he had with the case materials, he had no reason to conduct an investigation or to do the other duties that are entrusted to counsel because he wasn't counsel at that time. And I think that's the main relevance it has. Obviously, our other contention in this brief is that Mr. Rivera should not have been allowed to go pro se in the first place, but either way,
Why not? Didn't the court sufficiently advise him of the perils of going pro se?
The court did mostly advise him on the perils of going pro se. I think that...
What was deficient?
Two main things that I would want to address. One is that Mr. Rivera, during the pro se colloquy, said that he was using more drugs than he had ever used in his life, and the court didn't address the statement at all, acted like he didn't say that. I think for any voluntary waiver of a constitutional right, and including the right to counsel, what this court has said is that if there's a red flag about the person's mental state, you ask a question. Here, the court didn't ask any questions, breezed past it. The other thing the court did that was problematic here is that the court affirmatively misadvised Mr. Rivera about what the right to pro se was. The court repeatedly told him the right to go pro se was an absolute right. The Court of Appeals has said it's not absolute, it's conditional, and it can be revoked, as Mr. Rivera's right was later revoked if a person's conduct is interfering with the proceedings ongoing. But at the time that Mr. Rivera elected to go pro se, he was ignorant to that fact because the court had repeatedly misadvised him. So it's not right to say that he made a knowing and intelligent choice to go pro se because he had a misunderstanding conferred by the court about what that right entailed. I think both because he was without counsel altogether during several critical stages while he was pro se, and that includes the stage when he also waived his right to a jury trial. And because at trial he was constructively deprived of counsel, reversal is required here. We would also ask that this court consider exercising its interest of justice power to dismiss the indictments altogether here. Mr. Rivera served 6 years on this case. He has been on post-release supervision since February without any new arrests, and I think that it is in the interest of both justice and judicial economy that this case be dismissed. If there are no further questions, I'll rest on my brief. Thank you.
You may begin.
Good afternoon, Your Honors, and may it please the court. Julia Gorski for the people. The specific facts of this case do not support an inference that defendant could not have received effective assistance of counsel. The fact counsel obtained an acquittal on one of the top charges disproves that claim.
Counsel, my recollection is when defense counsel started, I don't know what his defense would be. I'm not going to make an opening statement. Doesn't that show that he was not prepared and had no ability to defend the defendant?
No, Your Honor. The attorney was not saying he had no defense, period. Each time he described that.
No, he said, I don't know what his defense would be.
Correct.
I think at that point, when you're defending a defendant, you should know at least what the defense would be. That means you're not prepared, even though he didn't say it.
At the time he made that statement, defendant had been granted the right to represent himself. He was appointed as legal advisor. The context of his statement is that I don't have the defendant here with me. The defendant is pro se. I don't know what he wants his defense to be. Unlike the cases defendant relies on, Pugliese had 40 years of criminal law experience, and he never complained that he was not afforded an opportunity to prepare the case. The record actually demonstrates that he felt adequately prepared to defend the case. He did not request an adjournment at that point, and we know that he was willing to do so because he did request an adjournment when he needed more time for summation. He also conceded that the case was not complicated and, quote, only consisted of a few exhibits in his motion to set aside the verdict. Again, he complained that he was unable to confer with defendant about what defendant wanted his defense to be, but that was a problem entirely of defendant's own making by voluntarily absenting himself from trial and refusing to talk to Pugliese after
Turning
the
to
fact.
whether the court engaged in the searching inquiry with regards to the defendant's request to go pro se. There's several things that were lacking from that inquiry, and I imagine you would agree. There was no mention of what the possible outcome could be, right, in terms of sentencing. Cumulative sentence. Was there a mention of that? Was there a discussion of that?
Not at that inquiry, but during a prior appearance before another judge, the judge had told defendant of his maximum sentencing exposure.
But the burden falls on this judge to do the searching inquiry because the application is before this judge to go pro se, correct?
Yes, but what I'm saying is,
in addition to that, and I'll let you respond. I'm not gonna stop you from responding. That would make no sense. There were other things that the judge didn't follow up, right? Your adversary pointed one other issue, which is this whole issue of him having been on drugs more than ever. There was, I believe, no questions with regards to that. Isn't that a problem?
no, Your Honor. It was within the trial court's discretion to determine whether or not an additional inquiry needed to be made here. Not every mention of substance abuse requires further inquiry.
Also, I take it that you are familiar that there is a model colloquy with regards to the searching inquiry for pro se, for defendants that wish to proceed pro se.
Yes.
Do you think that the court's colloquy here was in any way comparable to the model colloquy?
In important ways, yes. And while the court could have asked for that additional on-the-record confirmation that the defendant was competent and understood the proceedings against him, she did not have to do so here because everything else suggested that he had a full understanding of his case and was competent. For example, unlike the cases the defense relies on, there was no documentation, independent documentation, of a drug addiction or mental health issue. For example, there was no prior examination concluding that defendant was unfit or needed to be reevaluated. The instant offenses were not drug-related, and defendant's last drug conviction was in 2008. I would also—
Counsel, I'm a bit troubled, in light of the fact that, defendant says, I'm doing more drugs than ever, and then he would want to hang himself rather than, have the same attorney. That also didn't raise a red flag?
Well, I'll first address the drug comment. I think the context in which it was made is important here. This was at the first proceeding before Justice Pickles. She asked the parties to state on the record what the case was about. Defendant asked to address the court himself. He complained that his case had been dragging on for years, he had been trying to get rid of it for 3 years, and that all of his bail applications had been denied. He then continued, "What's the purpose of giving me a bail when you don't want to let me go? The original arrest was criminal possession of stolen property and possession of marijuana. This is a trumped-up charge on the contrary. I am an addict, unfortunately, so if a crime was committed, I think I need rehabilitation. I have had a long history of substance abuse, and unfortunately in jail, I'm doing more drugs than I ever have done in the streets. So if this is supposed to be a rehabilitation center, it's killing me more than it's keeping me alive." That statement of itself shows that defendant was competent. He understood the history of his case. He understood what had happened, what his bail had been set at, that it had been declined, and how long his case had been pending. It did not suggest that he was high or had just taken drugs, and that he was currently suffering from a condition affecting his competence.
Well, that may be true to a certain extent. What's missing from the colloquy is advising the defendant of the inherent risks of proceeding pro se.
The judge did advise defendant of those risks.
How?
She told him that, she elicited his education level, whether or not he had any legal training. She explained that he needed to know the rules of evidence. He didn't know the rules of evidence. She emphasized the singular importance of an attorney by comparing Hardy's experience with the lack of experience that defendant had, and that defendant would be at a serious disadvantage if he proceeded to trial representing himself because he was not fully equipped with the rules of evidence, how to get a document into evidence, anything that he needed to know to successfully represent himself. The judge's comment that he had an absolute right to represent himself when read in that context demonstrates that she was saying, this is a terrible idea, but I can't stop you. That you will have a right to represent yourself if you want to, as long as you're aware of the pitfalls and the dangers of self-representation, which she elicited from him on the record.
The court advised defendant the difference between counsel and a legal advisor?
She did not expressly advise defendant, I'm sorry, I see my time is up, of the difference between a legal advisor and counsel, but she did stress the importance of having someone who was trained as a lawyer representing him and emphasize that even lawyers accused of crimes have other lawyers represent him. It's also
Thank you.
Okay.
Thank you.
A few points, Your Honors. Mr. Rivera's drug history is all over this record, and that makes it very similar to this court's decision in Z regarding a red flag about someone's mental state. The prosecutor himself...
This is not a case where the justice below was intimately familiar with the defendant, right? In fact, she came onto the case maybe a month before.
Actually, no, Your Honor. This was Judge Pickles' first appearance on the case.
First appearance, okay.
Was the same appearance with the drug comment. And so she did not personally hear, but at a previous proceeding, the prosecutor had actually reported to the court that Mr. Rivera had infractions from using pills in Rikers. Mr. Rivera, at previous appearances, had raised the possibility of a diversion program because of his drug addiction. The prosecution also just noted that when Mr. Rivera said this, he noted one of the original arrest charges here was drug-related. Drugs are all over this record. I think maybe that this was Justice Pickles' first appearance, deprived her of some of the personal
Well,
context.
this was his second appearance before Judge Pickles, right?
This was at the
when
first
it went to
appearance?
trial.
This was at the first appearance, and then she does a second pro se colloquy after this. But this is the...
So there were two pro se colloquies,
Yes.
right? And this first one, she said she told him that she would advise him to think about it, right?
Yes, but at none of the colloquies did she address his drug use. Did she correct her misadvisement that the right to pro se was absolute? Did she say that he faced a 45-year maximum? Or did she fulsomely advise him about the dangers of representation and the importance of a lawyer? I would ask this court to look at the Court of Appeals decision in Baines, where the Court of Appeals said that brief generalized warnings like the ones here, that you have to know evidence and you have to know cross-examination, were not good enough. What the Supreme Court has said is that we must indulge every reasonable presumption against waiver. There are a lot of red flags here. The reasonable presumptions do not support a valid waiver. Unless your honors have any further questions, I'll rest on my briefs.
Thank you very much, both of you. Piscatelli versus Deloitte Services.
Good afternoon, Your Honors. I'm David Garland on behalf of the appellant. So may it please the court, I like to think that this is should be one of the quicker arguments of this long afternoon for you, because really the focus of this appeal is the disability discrimination claims pleaded under state and city human rights law. And when...
Didn't the plaintiff in their brief in this case indicate that they were really not claiming pregnancy in the context of a disability claims, and didn't they sort of kind of take that out of the case anyway?
Your Honor, that's how I read the brief. So
that's how I
below,
read the brief.
Yes, below they were taking the position that there was a disability discrimination claim in the case, and the motion judge took all the first four counts, first causes of action in the complaint, which were all discrimination. The first two pleaded as sex discrimination, and the third and fourth pleaded as pregnancy and disability discrimination. And then when we moved for summary judgment on the grounds that there was no disability evidence presented in the record, that there was no accommodation request that was not granted in the record, the court just blended the first four together, didn't address that. And so we're going to trial now. We have still a disability discrimination claim in the case. But yes, I read the brief.
It seems to me that it sort of got worked out in the brief, and not for nothing, the next part that you were appealing about, the 8th and 9th causes of action, was just a mistake on the judge's part to not realize that those causes of action had been discontinued without prejudice, with prejudice, years before. So what are we really arguing about on this?
We shouldn't be arguing, based upon the briefing, anything at this point. The court should reverse the order below to make clear that the disability discrimination claims are out of the case. And likewise, the 8th and 9th counts, which the court says are still in, no, they're out. And so to vacate the order.
I don't think there's really any dispute on that.
There shouldn't be. We wouldn't be here if it were just for those two counts, the 8th and 9th. We had to address the 3rd and 4th, the disability discrimination, and as long as we were here, we thought it was proper to address the 8th and 9th counts as well. All right. I'll rest on the papers.
I didn't see too much dispute in this appeal.
Good afternoon again, Your Honours. Neil McIlroy on behalf of plaintiff respondent. We are in some agreement. There isn't much dispute, and I think I too will be short. But I will say this. It's not simply that it wasn't argued in the brief that there's no disability discrimination claim. It wasn't argued below either. If you look at the memo, that's not the argument. If you look actually at the transcript of oral argument, it never once comes up. There's no argument made by anybody that pregnancy is or isn't a qualifying disability. Even if you look at the complaint itself, you have two causes of action that are entitled pregnancy/disability discrimination. CPLR 3014 requires separately stated claims. So you can't, in a single or under a single cause of action, assert both a pregnancy discrimination claim and a disability discrimination claim, and that's not what's done. There may be an element of inartful pleading, but nonetheless, it was never argued below. It's never mentioned in the memo. The discrimination is exclusively argued under the framework of either gender or sex-based discrimination. Never mentioned at oral argument and doesn't appear in the decision. Now, the only significance is this, and the reason we would ask for the lower court decision to be affirmed is what defendant wants here is you have four causes of action, two under the state, two under the city human rights law. The first two are for sex discrimination. The third and the fourth are for gender discrimination. Plaintiff here wants to be able to assert both a sex discrimination claim, or a pair of them, and also freestanding pregnancy discrimination claims. Not disability discrimination claims, pregnancy discrimination claims. That's what the court allowed below. What defendant here wants to do is have the freestanding pregnancy discrimination claims dismissed. That's the dispute, as it were. Now, in terms of the 8 and 9, the judge didn't, to quote the brief, resurrect these claims. They were dismissed with prejudice at the outset of the case. The lower court said that, and it appeared to overlook, you didn't meet your burden on summary judgment. Well, they're gone in the first place. That does not resurrect them. I'll also say this. There was a motion for summary judgment made below. The pleadings were not attached by defendant. Plaintiff attached only her own complaint. So what I would say, if we're to get very technical on this, the answer is in the record. It's at the outset of the record, but it was not part of the lower court record. CPLR 3212B is very, very clear. You have to attach the pleadings. There is case law from this court and elsewhere that if the pleadings are found elsewhere within the record, i.e. if the opposing party includes them or if they're included in the reply papers, but that's not the case here. So, what I would suggest here is this is not an appeal that should have been taken. Causes 8 and 9 were dismissed at the very outset.
I don't really think you should spend time on that. I think we all are in agreement on that.
Indeed. So in terms of, what's the significance in terms of the remainder of the appeal? It's that plaintiff is entitled to pursue both a sex discrimination claim and also a freestanding under both the state and city laws gender or pregnancy discrimination claim too. To characterize it as a disability discrimination claim that should be dismissed, it's not what the court below found. It has never been plaintiff's position, and this court should affirm the decision below. It's the idea that despite this record, the plaintiff is going to show up at trial and argue disability discrimination, I think is quite incredible. So in conclusion, I would ask that the decision below be affirmed.
So just to clarify, your client is not asserting a pregnancy disability claim, right?
She is asserting a pregnancy discrimination claim.
Okay, on the
She's
basis...
not asserting a disability
All right,
discrimination.
and that is on the basis of gender, on the basis of sex discrimination, the pregnancy.
Indeed, Your Honor. We're asserting 2 gender discrimination claims and also 2 pregnancy discrimination claims, as it were, a subset of the gender discrimination claims, but we believe we're entitled to assert them as separate freestanding causes of action.
I understand. Thank you so much.
I'm afraid there's a lot less agreement than I thought existed when I sat down. First, and with all due respect to counsel, he didn't appear in the case below, in the court below. There are sections in the briefs, and you've got them in the record, where we specifically address the disability discrimination claim and 2 pieces of it on termination and the reasonable accommodation. So it's there, and so that's in the record. Next, this is the first time that I'm hearing in this case that no, we want 2 different claims now. One styled as sex, and a second styled as pregnancy discrimination. That's not been in the case before. That's not argued in the briefs, below or here. So as the Court of Appeals has said, as this court has said, as the other departments have said, pregnancy discrimination is a form of sex discrimination. This case is about pregnancy discrimination, and the motion judge, and this may be in the record as well, I wish I could point it to you right away, has said earlier in the case that the gender discrimination claim is pregnancy discrimination. There's not a separate sex discrimination claim that she was treated differently than men. It's all about was she treated differently than non-pregnant employees. And so for that reason, it's important for this court to reverse the denial of the motion and dismiss the third and fourth counts. The plaintiff is free to move forward and will move forward with the first and second counts for sex discrimination, which encompasses pregnancy discrimination, is pregnancy discrimination. Thank you.
Thank you. Rosenblatt v. Rosenblatt.
Good afternoon. May it please the court. My name is Michael Benuchis, and I represent the appellant Marvin Rosenblatt, and we are asking the court to reverse the trial court's order or alternatively remand it back down for further proceedings.
You're claiming, aren't you, that because of this dispute, the agreement that the parties entered into required them to go to mediation before they came to court?
That's my layup argument here for what the court did wrong. Because, so the dispute covers any argument or any dispute, sorry. So what the judge did was essentially delve into the law dictionary and say that what these two parties were arguing about, which is whether there was interest included on this loan or whether my client had effectively exercised his buyout arrangement, were not actually disputes. These were defaults. They were not covered by the extremely comprehensive term, any dispute, and therefore, with no evidentiary hearing, she ruled against him. So,
But there's a dispute as to whether there's a default, right?
so the issue is, if you were to
Between the parties, right? The
Between the
parties are, there's a disagreement about what has transpired as it relates to the positions on the default.
Yeah, so the way that the court...
So that's a dispute.
I would say that it is a dispute, yes. And I would say that the way that the court kind of grappled with this issue is to say that if you hold the mediation clause, you hold these parties to the mediation clause, then the default clause is therefore rendered ineffectual. But I don't think that's the actual right reading of how it should be. I think it's...
Well, the default clause requires certain notices be given, right? But
Sure, yeah.
regardless of those notices, any issue regarding a disagreement, whether it's based on the default or not, should be mediated first.
Exactly.
Save some money and go to mediation before you come to court.
So just as a matter of policy, generally courts will say, particularly when there are ADR provisions in an agreement, that parties shouldn't go and run to court. You go and mediate first. If you can't figure it out between yourselves, the state of New York, through the proxy of the Supreme Court, will figure it out for you. And that's not what happened here. And so when my client brought that up, the trial judge essentially just said that, no, these don't count, even though there's nothing in the actual, the terms of the provision that would dictate that these weren't disagreements that should be mediated. Further, when it comes to the salient issue here is whether or not there was interest, accrued interest on this loan. And so again, the court, rather than saying, we have a factual dispute here, let me gather evidence, we'll hold a hearing, and we'll see what actually these parties, if there was a meeting of the minds, and what should happen here, she again just delved into the law dictionary and said, this loan, by black and white definition, has to have included interest or accrued interest.
Look, she went into the merits. You're claiming she shouldn't have done that.
Well, I think that she should have held a hearing to figure out what, because I think that it's ambiguous, because even the wife wasn't sure what she was entitled to. She sent my client an email saying, by the terms of the agreement, I'm either entitled to 30 or 50% of interest. Now, she's assuming that she gets interest, but she wasn't even clear as to what she was afforded to. So for the court to say that this is totally unambiguous when the parties are, one, disagreeing over whether interest is included, and two, how much interest is included, clearly would indicate that there was no meeting of the minds. This is ambiguous, and it should, at the very least, with this sort of factual dispute, kick down to an evidentiary hearing.
Or go to the mediator, there's a dispute.
That would be if the first part, and then if not, judge will figure it out for them.
All right.
Good afternoon. May it please the court. Robert Moses for respondent, Ms. Rosenblatt, who is actually in the audience here. So I want to first talk about how there was no effort whatsoever by the appellant to actually try to resolve the issue through mediation. Not at all. It only came up afterwards, after there's a clear contract, which was heavily negotiated. I was there. We came to a
The provision of
contract.
that heavily negotiated contract was that if there are disputes arising from that contract, you first either try to negotiate. If that doesn't work, you go to mediation, and then if that doesn't work, then you come to court.
That was not in a default situation. So in a default situation, the relevant clause does not talk about mediating.
What is
Because that
the relevant clause in the default provision talks about giving notice of default, right?
And my client gave notice of the default, and she tried to work it out. And the
What
dispute
else
was
does it
on
say
other
about
issues.
how
The mediation
to,
was supposed to be about other.
I'm
sorry.
talking. I'm asking a question. My lips are moving.
Sorry about that.
Okay. Within the default provision, what does it say about how, according to your reading, since you were there when the contract was negotiated, what does it say about how a default issue would be resolved?
It would, with a notice that my client gave to cure it. She did. She waited 4 months.
So after the notice to cure, then what would happen in that scenario in the default provision?
If he's not abiding by the agreement, it was either to sell or buy out. There were only two things to do. To mediate was not that provision. It was basically if you're not going to follow the agreement in and of itself, there's not a dispute. That's not a dispute. That's a default, and you're not. There are only two ways. What are you mediating?
At the heart of a default is a disagreement, right? So maybe if we don't call it a dispute and instead call it a disagreement about whether you've lived up to the terms of the contract, the provision is you mediate that disagreement.
And I say the cost of that mediation, the whole idea was not to mediate a clear default, because in the default provision, because to do that, then the idea would be
Wasn't there a question actually as to whether this actually was a default? Because it seems that the other party changed his mind a few times. Was he going to buy out your client? Was he not going to buy out your client? It was very confusing. To me, it seemed more like a dispute that ought to all get taken care of together.
But the appellant never sought to mediate it, so she had no other choice but to go to court. He had 4 months to mediate it. He never sought the mediation because it was black and white. It's either you sell the apartment or you buy out the apartment.
But there's also another question about the loan, and that wasn't so black and white. That's out there also.
Well, the loan interest, the court looked at what a loan is. If a loan doesn't include interest, I don't know what the definition of a loan is. And there's no real dispute about what a loan is as far as I understand.
Well, I thought there was a dispute.
They weren't
I read
disputing the
about it in
amount.
papers.
You were not. There's no dispute over the amount. It's disputing what the term loan
I
means.
understand that, whether or not interest was included.
I'm not sure what you're going to mediate. If we all agree this is the amount, and then it becomes, is it a loan or not a loan? A loan includes principal and interest. So for him, he's saying it includes principal and interest. The same sentence says 70% of that loan repayment. For him, it included principal and interest. For her, it doesn't include it, and they're the same exact words.
Sounds like a dispute to me.
I just want to hit on a few things. One, it would seem to me that the mediation and default clauses are just not drafted in unison with each other. It says that they make sense, and I don't know if there's anything we can do about that, but it would seem to me, send a default notice, say, let's mediate it out, and then if you can't, you go to the court and say, hey, I followed the instructions, I followed the agreement, I put the other party on notice of the default, and now we're in court because we couldn't figure it out.
Your client is disputing that there's a default.
Yeah,
right?
He's disputing that there's a default. We're not conceding that there was any default.
That's what I said.
My other issue is that, just a practical one, I think that I would suggest and hope that the court would say, remand parties to mediate, if not evidentiary hearing, or else we're going to be stuck with the same order, essentially, and then we'll be back, be back here again. So our position is that the court should remand, direct mediation, and then direct the lower court to set it down for an evidentiary hearing on the issues of the buyout, which may resolve itself, but more importantly, the loan issue.
Thank you both.
Thank you.
Rubenstein Public Relations versus Fleet Financial.
Good afternoon, Your Honors. Jan Marcus with the DRL Law Group representing the appellant. We're here because of a default judgment that was entered against the appellant, and the trial court would not agree to vacate the judgment. So we're dealing with CPLR sections 5015 and 317. Under the first section, 5015, whether it's A1 or A4, which were both raised, there has to be showing of excusable reason for not having answered. And here there was no answer for a period of more than a year, and that's the second part that would have to be shown. But there was a valid reason for that. As the appellant pointed out, the process was never received, and any subsequent mailings were never received. Now, ordinarily, that may not be enough, just saying we didn't receive it, but that's not what the appellant said below. The appellant said that it was not received, and the reason it wasn't received is because the complete address wasn't used. The appellant is in a complex, according to the affirmations submitted below to the trial court, that contains hundreds of small commercial units. And if you don't put the suite number on there, it's going to get lost. The affirmations also showed that what was registered with the Secretary of State included that suite number, and in fact, the respondent could have found that just by looking at the website. So that part of it, that prong of it under 5015 is satisfied. Now, the trial court did not really deal with that and focused on the claim under CPLR 317, which says even if you can't show anything that's reasonable why you didn't appear, you can still vacate the default if you show a meritorious defense or you have a potential meritorious defense.
I have a question because, okay, fine, Unit 10F wasn't on there, but, when you're looking at the letter agreement, all of the invoices, the unit number isn't on there also. So, is it that you didn't get the invoices? That's why you didn't pay? You didn't get the invoices? It didn't have the Unit 10F? I'm just curious.
Well, I will answer it this way, Your Honor. If the default had been opened and an answer could be filed with the defenses, affirmative defenses asserted, and maybe even a counterclaim based on what the affirmation of the appellant was below, whether that's going to be a tough thing to prove for the appellant or not as a defendant in that case, that remains to be seen. That's the burden. That's what they'd have to do. But to not allow the defenses to be asserted in the first instance, and I agree that the affirmation does not exquisitely set forth the the defenses, but it does say that the services rendered were ineffectual, and therefore they're not owed the money. The plaintiff's not owed the money, in fact, caused us damage. Is that enough in the context of a default judgment? The answer is yes. I mean, it would be a lot better if more detail were put in there. As Your Honor just pointed out, if there were emails and said, look, we're unhappy with your services, that would be terrific. It would take the pressure off this argument here for the appellant a little bit. But we have what we have. And is that enough? And the overriding principle that this court always points to is that people should be given their opportunity to present their day in court, to present the defense and to see where it goes. If I am drafting the answer and I put in as affirmative defense exactly what the appellant put in the affirmation on the motion to vacate and said, as a first affirmative defense, the plaintiff did not provide valid services or sufficient services, and as a result of that, we don't owe the money, and in fact, we're owed money.
Yeah, it just seemed to be really conclusory, just to say, oh, it was, and I'm just using my words, substandard, no explanation, particularly since you pay 6 months and then all of a sudden, no payment. So,
I agree it's close, Your Honor, but I think, again, with the overriding principle of allowing somebody to have...
month after month, January, February, March, April, May, June, straight payment, no complaints. So obviously, they're doing something right. And then all of a sudden, July through December, and then, oh, it's just not worth the $90,000.
No question what you're saying is right, Your Honor, but things can change, and that's why I say, if we got a chance to do discovery and go through that, we'd see where it went.
Let's hear what counsel has to say.
Thank you, Your Honor.
Thank you.
Yes, good afternoon, Your Honors. May it please the court. Eric Schutzer on behalf of the plaintiff, respondent, Rubenstein Public Relations. I want to begin by noting that the appellant didn't file a reply brief here. So every legal argument that's in my brief, including that the record was incomplete and therefore the appeal shouldn't be heard to begin with, and that the motion to vacate the default judgment was filed more than a year after notice of entry of the order granting default judgment was entered, so the court was within its discretion under 5015 to deny the motion outright based upon untimeliness, as well as that the presumption of proper service through the Secretary of State is that it's valid service, and finally that the defendant failed to make any raise any meritorious defense. I'll point the court to the record on page 139. It's emails from the defendant, Mr. Zia, where he admits he receives the invoices from the plaintiff, and he said he'd get to address
Are those the invoices that did not have the suite number on them?
Yes, Your Honor, I believe so. I mean, all the invoices were not only mailed, but they were emailed to the defendant, and the defendant received it, acknowledged receipt, and promised to address it. No dispute. There's nothing in dispute. There's nothing in Mr. Zia's affidavit in support of the motion for default judgment that says, I didn't get the invoices. I disputed the invoices. Nothing to that effect. And that's insufficient, Your Honor. The trial court was well within its discretion to deny this motion. It did the proper thing. And the record here is incomplete. So the appellate, the trial court referenced my attorney affirmation, NYSIF document 42. It's in the decision, but it's missing from the record. Not in the record, the defendant didn't put it in there. Based upon that, based upon O'Barry versus Gelco, First Department 2015, the record's incomplete and the appeal shouldn't be heard based upon that basis alone. However, again, as I pointed out, the motion was untimely, service was proper, and the fleet provided no meritorious defense. Does the court have any questions?
Nope. Thank you.
Just briefly, Your Honor.
Give me a second.
Your Honors.
Give me a second. Please begin.
Thank you. The argument that the respondent's affirmation was not part of the appellate record, that affirmation is more in the line of a memorandum of law with legal arguments, and that's not going to be included in the record. If the respondent felt that that was so necessary, it could have moved to amend the record and get that included in. As far as not a reply brief, I candidly can't tell you why that wasn't filed. I don't know. That preceded our entry into the case. That doesn't mean everything is conceded. I've never seen that held by any court, that if you don't put in a reply brief, you're conceding everything in the answering brief. There are no further questions. Just rest on the papers.
All right. Thank you both.
Thank you.
People v. Thompson. me a second, sorry.
Of course.
I'm having clock issues. Give me a second. It's, yeah, it's not. Yeah. Okay, there we go. Yep. Got it. You can, court officers told me that. Go ahead. Thank you.
Good afternoon, Ian Peters, under the supervision of Clara Hammond Oakley of the Legal Aid Society, pursuant to the student practice order, appearing on behalf of appellant Mr. Juleshawn Thompson. Mr. Thompson's sentence of 2 to 4 years was excessive and should be reduced for 3 reasons. First, the record here reflects that Mr. Thompson was in an acute psychiatric crisis when he committed this bizarre offense. Second, Mr. Thompson's struggles, as well as his successes, should be viewed in light of his unstable childhood and particularly his involvement with the foster care to prison pipeline. And number 3, Mr. Thompson had achieved considerable and impressive stability, which underscores his unique potential for rehabilitation. First, I'd love to just point out that Mr. Thompson has a long diagnosed history of PTSD, and on the date of this offense, the complainant herself described Mr. Thompson as scared, very sweaty, and nonverbal, and in fact showed concern herself for Mr. Thompson, asking if he was okay, approaching him. And in his pre-sentence interview, Mr. Thompson himself reported that he didn't remember the event itself, that he had trouble, placing himself. And we know that PTSD sufferers, such as Mr. Thompson, can experience symptom reactivation, which is an acute increase in symptoms following a subsequent traumatic event. And we know that Mr. Thompson experienced exactly that.
The mental health issues that are at the heart of the mitigation, is it PTSD or is it also an additional mental health issue?
So, yeah, Mr. Thompson, PTSD is only one of his diagnoses. That I think PTSD best frames this event. However, he is diagnosed schizophrenic and bipolar, both of which were diagnoses that he received in his teenage years, and are obstacles that not only frame the difficulty experienced coming up, but also frame the really impressive progress that he was able to make as an adult. By 2022, Mr. Thompson had received his GED. On the day of this offense, he was in the park with his daughters. After a really turbulent experience in the foster care system, he had reunited with his mother, who he now...
The defendant has a criminal history, correct?
It's true, yeah. He does, and his last conviction was also in his teenage years. And although, I'm sure...
He was sentenced as a predicate?
He was sentenced as, this is his second felony. However, he was a teenager at the time of his last conviction. And I think that what his criminal history shows is actually the impact of this really unstable childhood that he experienced and the capacity that he had to move past that and mature in ways that are truly impressive.
Was this before the sentencing court? The arguments that you're making to us now in terms of mitigation, was it before the sentencing court?
It's true that this material was in front of the sentencing court. However, it's our position that these really substantial factors were not taken into account enough by that court, and that that Mr. Thompson's sentence, in light of the really serious mitigating factors, both at the time of the event and framing his childhood, make this maximum...
What do you say to the argument that, for purpose of my question, we're accepting your mitigation argument?
Yeah.
What he did here was traumatizing, right? This child's going to have to live with the impact of this, the mother. How do you offset that?
Absolutely, and I just want to take a second to say this. This was an admittedly terrifying instance for the mother and for the child, unquestionably. However, the mitigating circumstances, I think, not only reduce Mr. Thompson's culpability, but also just frame his unique potential for rehabilitation. What we know about, he himself has expressed a desire to get treatment, and what that is in part a response to this event itself. He'd made such progress, but even his mental health issues had followed him through that progress. Getting out will allow him to be reunited with his family, be in an environment that we know is more effective in terms of treating the underlying issues that frame this case.
Did the defendant face between 5 and 15 years in jail?
It's true but I would say that this is a really bizarre and abnormal attempted kidnapping charge. As we know, it was underscored by this acute mental health crisis, and that he pled guilty to this because he did it. However,
Well, he pled guilty to the
to the custodial interference because he.
right. I just don't want it to seem as though you're saying he pled guilty to any kidnapping charge.
Absolutely, I appreciate it, Your Honor. He pled guilty to this charge, to custodial interference, because he took responsibility and because he did this.
You know what? You brought up that responsibility because actually the people would argue otherwise. You know, the people indicate in the brief that the defendant did not take full responsibility in light of the statements in the pre-sentence report, right? That, you know, he was unfairly imprisoned for the wrong case. And really, all of his statements talked about how the case affected him rather than how the case affected the victim. And certainly that he, you know, took a plea that was unfair. I mean, these were all in the pre-sentence report. So what is your argument with respect to that, your response with respect to that?
Yeah, I think that it's very clear from the PSR, probation was very clear that Mr. Thompson admitted his guilt. And it's true that they had a very long conversation with him in which he expressed his confusion, and that confusion itself is reflected in the grand jury minutes, but also importantly, I think in that pre-sentence interview, he also expressed a desire to get treatment and to address the underlying issues.
So, counsel, two things can be true at the same time, right? Where he felt like this was a long sentence and he also took responsibility for his conduct, right?
Yeah, I would agree. Thank you, Your Honor.
All right, thank you.
Good evening, Your Honors, and may it please the court, Robert Butland for the people. Defendant's negotiated sentence was fair and appropriate in light of the shocking nature of this crime, which, as was mentioned before, could cause lasting trauma in the victims.
In terms of the sentence, what are we looking at in terms of the time left that he has?
I believe his earliest release date is February of 2026, so a few months from now, and then 2 years after that would be his latest release date.
Right. And so what the defendant is asking for would effectuate about the same time of release, or?
I'm not sure exactly what sentence reduction defendant's asking for. I think they just asked for a broad reduction. But I think the potential closeness between his earliest release date and this extensive sentence claim isn't really an appropriate question, because whether or not he could be released soon doesn't actually answer whether or not the sentence was excessive. And it really has nothing to do with the case at hand. And importantly, the crime here bespeaks a public safety issue here. Of course, defendant needs treatments.
Well, a part of the calculus of the excessive sentence is the length of it, right?
Of course, Your Honor. The length does matter. And it is argument that the length is appropriate here in light of the nature of the crime, defendant's criminal history. This didn't happen in a vacuum. And the mental health issue is certainly important here. It's absolutely part of the picture. The people do not dispute that.
Part of the picture, right? Because it seems to me that the complaining witness itself is the one that frames it the best. Right? The complaining witness says that she observed that the defendant was under distress and asked him if he was okay.
Yes, Your Honor. Again, there's no real disputes about the mental health issues in this case, but I have a few points on that. So yes, there was a mental health issue that clearly played a role in this, but that's not to say that he's not legally culpable or that he shouldn't be given a sentence in general. And of course, defendant does need treatment. This crime bespeaks that. But treatment and incarceration are not mutually exclusive. They're not a forced choice proposition. Defendant was not being medicated when he did this crime. And under the supervision of docs, he can get treatment.
You're not suggesting that in incarceration is equivalent to treatment, are you?
No, I'm not saying that treatment and incarceration are one and the same. But for someone like defendant who was not being treated before he committed this crime, there's an outstanding public safety issue. So his incarceration serves a very important purpose of incapacitation. And moreover, because—
Can I shift it to responsibility? Because there are many statements in the record that where the defendant says he was in prison for the wrong case and that he only talks about it affected him. Isn't that part of the calculus as to whether or not this court should take up interests of justice?
I think it is, Your Honor. You know, acceptance of responsibility got him this plea. He did the bare minimum for that. And I understand that this might have been a complicated case for him. He was battling a lot. But this wasn't so much as saying, I wasn't under the right mind, and I'm so sorry for the victim. I don't think it moves the needle in terms of mitigation, but in any event, that mitigation, the mental health issue, all of the mitigation we spoke about today was before the sentencing court.
The Department of Probation concluded in the pre-sentence report that the defendant failed to accept responsibility?
No, again,
Quite the opposite, correct?
Yes, defendant did accept responsibility, but it's our argument that he did the bare minimum to do that. This is not so outstanding an acceptance to responsibility, showing of contrition, showing what he needs to improve, that his sentence should be reduced. He did accept responsibility, and that entitled him to the plea that he received.
That part of what's lacking in your view is that he's affected by mental illness?
No, Your Honor. Again, there's no doubt that he has mental illness, and I'm sure that played a role in this. But it's important because of the public safety issue that he does get treatment, he does get incapacitation. Again, the sentence here—
I agree with you in terms of, maybe I would agree with you in terms of capacitation, but I don't think anyone in their right mind would think that putting someone in jail in our system is treating mental illness.
Your Honor, but he wasn't being treated outside of prison either.
That may be
Docs
true, and that's a separate problem, but prison is not going to resolve that.
No, Your Honor, but it actually can help because he needs to take accountability, and he does need treatment, and DOCS does have treatment. Again, I'm not saying incarceration is treatment. I know it's especially hard for people with mental illnesses, but we can't pretend that DOCS does not offer treatment, that defendant doesn't need treatment, or that exactly, and that he can get it in prison. And a reduction in his sentence would actually reduce the amount of supervision that he could receive from the state and increase public safety issues.
Thank you.
Thank you, Your Honors.
So I would just like to really quickly correct one thing that my opponent said, which is that the max is actually, Mr. Thompson's max sentence would not be expiring in June 2028, but actually in June 2026. So our ask is actually much more humble than framed during that while he was talking. But I would just like to refocus in response to the prosecutor's framing of Mr. Thompson's acceptance of responsibility. And I think that where probation was very clear that he did accept responsibility, I think the emphasis here should be also on Mr. Thompson's really clear, explicit desire to receive treatment. Him getting out will allow him to get individualized treatment that is more effective than what he's able to get in prison.
Before he was incarcerated, he was under the condition of the mental illness as well as the PTSD, and he wasn't receiving treatment, right? He had not gone on his own to get treatment, right?
He's not, but as I believe that he was not able to receive treatment there. But as I mentioned a moment ago, I think that this event itself has really was a moment that enabled him to see that despite the really significant progress that Mr. Thompson was able to make, that these mental health issues still are an undercurrent that he will likely have to deal with and address proactively in his life. And that will be true when he gets out regardless. And I think that what we know about prison and the environment that it offers to people dealing with these really serious mental health issues is that he would simply be able to receive better and more effective treatment, individualized treatment, while not in prison.
Are you saying that at the time of the incident he was incapacitated, or he was unable to understand the significance of the plea which he took, which reduced his sentence from possibly 5 to 15 to lesser sentence?
No, certainly. I note that the prosecution said something about his legal culpability, and at no point in time do we, assert that he's not legally culpable for what happened here. However, I think that what our emphasis is that these really serious mitigating factors, while they were before the sentencing court, were simply not taken into account enough. And given what we know about his history, what we can glean from the grand jury minutes as to his mental state at that time, and also framing his really impressive progress just enables us to see what will most appropriately serve Mr. Thompson here.
A question for you.
Absolutely.
What law school do you attend?
I go to NYU.
Let me say, you were excellent. Job well done. Job well done.
Thank you, Your Honor. I appreciate it.
The other side, too.
The other side, too, but, law students, we have to really, really, well done.
Appreciate it.